on, but their audio is on mute. Okay, thank you. And let's wait for the recording to begin. I think I have our court reporter. Okay. All right, again, good afternoon. My name is Judge Law, and this is the final plea calendar with the Orca cases, which are misdemeanor criminal cases with the State Court of Fulton County. If you are a defendant who is appearing in person in courtroom G33, or if you're a defendant appearing via Zoom, please remember that you have a right to remain silent about the fact of your case. If you make any comments about your case in either an open court or in Zoom court, please remember that your statements can and will be used against you in the treatment of your case. Also, please note that the entire Zoom proceeding is being recorded as well as live stream. I'm going to be doing a roll call with regards to the cases. I already have some cases lined up to take pleas. So before we begin, I have a motion to revoke bond with regards to Nigel Flukes. Is Mr. Flukes available in the courtroom?
He's present, Judge. Mr. Fuchs.
All right, thank you. Deputy, you can have him in as close to his counsel so that he can assist in his case. All right, Mr. Nigel, am I pronouncing it correctly, folks? Okay. Mr. Folks, again, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel today is Mr. Jawan Haddad. Motion to revoke bond with regards to Mr. Folks filed on October 24th, 2023. Ms. Reiser, you are advocating for the state. You may proceed.
Thank you, Your Honor. Yes.
Our court reporter is good to go. Yes. She's on Zoom. Ms. Carter, you good to go? All right, good. Thank you. Yes.
And Your Honor, is it okay if I remain seated for purposes of Zoom and the microphone?
That's perfectly fine.
Thank you.
Same courtesy to defense counsel as well.
I'm okay standing.
Okay, just make sure you're close to the microphone.
All right, I will, Judge.
Yes, Judge. The defendant has 3 open cases that are on this calendar. The first case being 19 CR 005796G. Second case 22 CR 005846G. And the last case being 22 CR 000129G. The state filed its motion to revoke bond on October 24th, 2023. That was e-filed.
I'm sorry, did somebody make a comment on Zoom?
I probably need to slow down. I talk fast.
Ms. Carter, I'm sorry, you're muted, Ms. Carter. Did you have a comment?
I can't hear her clearly, but I'll see how it goes when she slows down.
Right.
Sorry, Ms. Carter.
Thank you, Ms. Carter. All right, Ms. Reiser.
Yes, Your Honor. The state filed its motion to revoke bond on October 24th. Are you on Zoom? No, I'm not on Zoom. No, because that's my microphone. Can you hear me okay now, Ms. Carter?
Yes, that's fine. Thank you.
Thank you. The motion was filed on October 24th, 2023 in all 3 of the cases, Your Honor. That was e-filed and served on the public defender, Mr. Frank Gaither, who is counsel of record. When I made the court aware of the state's intention to proceed today, I also reached out to Mr. Haddad, who is standing in for Mr. Gaither. Mr. Gaither's out on leave, but Mr. Haddad was served a copy of the motion. We discussed it pre-trial today. And I believe Mr. Haddad has agreed that the state can proffer what's in our motion and any additional information. Is that correct, Mr. Haddad?
It is, Judge, and I can elaborate a little bit more in a second.
Yes.
You may proceed.
Thank you, Your Honor. The victim in all 3 of these cases is Ms. Kamisha Ragland. She is present in court today, Your Honor. And I just kind of want to go a little bit through the procedural posture of the cases and why the state is asking for the defendant's bond to be revoked. So the first case ending in 5796G stemmed from a February 13th, 2019 incident where the defendant was or is charged with simple battery against a person who's pregnant. In that incident, it is alleged that he threw pots and pans at the victim, Miss Ragland, while she was holding her child. She was also pregnant at the time. He was subsequently arrested and released on a $2,500 signature bond. When he was released on that bond, his bond conditions included to have no further contact with Kamisha Ragland and a stay away from the 2980 Delmar Lane. In my motion, Your Honor, I did attach that order that order for bond outlining the conditions of it. The second case originated on March 15th of 2020, where the defendant was initially charged with aggravated stalking and simple battery. In that case, while he was out on bond for the 2019 incident, he was alleged to he attacked Miss Ragland, pulling her hair, choked her and punched her in the face. The incident in March of 2020 was witnessed by a neighbor who informed police that the defendant was the primary aggressor and he did in fact punch Ms. Ragland in the face. He was again arrested and charged. And in that case, Your Honor, since he was initially charged with ag stalking, that was up with the DA's office and he received a $25,000 surety bond with the same conditions of no further contact with Ms. Ragland and a stay away from the 2980 Delmar Lane. The DA subsequently DWAP'd the ag stalking and the case was transferred to state court on the charges in case number 5846. While he was out on bond on not only the $2,500 signature bond, then the $25,000 signature bond. In January of 2022, the defendant was again alleged to have committed the offense of battery, family violence, and cruelty to children in the third. When he got into another argument with the defendant, he scratched her on her chest, spat in her face, or spit in her face, and there was an allegation of choking in that case. He was again arrested for battery, family violence, and cruelty to children. He was released on a $3,000 cash bond and with the same conditions of no further contact, and I believe it was a stay away. And as I previously stated, Judge, all of those bond orders are attached to my motions with the police reports. While he was out on bond for our three cases, the police were called again on August 29th, 2023, when the defendant was alleged to have pushed the victim down the stairs. That police report is attached to the motion. It's my understanding the defendant was not arrested for that incident. However, police did come out and document the incident. And then as of most recently, Your Honor, early October, around on or about October 3rd, 2023, while the defendant is out on bond in three of the cases, it's alleged that he punched the victim in the eye, causing her to have a swollen black eye. I have attached to the motion, Judge, the photograph of her injuries. I have another copy of it for the court's consideration. So, Your Honor, since the defendant has been released on bond, he has continued to commit multiple acts of violence against Ms. Ragland. He's been in direct violation of his bond conditions to have no further contact with her. I believe it's apparent, Your Honor, that no amount of bond and or no conditions are going to prevent further violence towards Ms. Ragland. The parties do share children together. But, you know, he's had every opportunity in three cases. First, it started with a signature bond. Then it goes to a surety bond and then a cash bond, all with the conditions. And he continues to display a lack of respect for the court's order while he's out on bond and continues to commit further acts of violence against Ms. Ragland. Like I said, Judge, she is present in the courtroom if the court would like to hear from her. So based on all of that, Your Honor, I would ask that you revoke the defendant's bond and hold him until the trial of all these cases.
Okay. Mr. Haddad?
Thank you, Judge. Judge, just to start with, on paragraph 8 of the state's motion, it states that on or about October 3rd of 2019, that she had suffered a black eye. And that's what I was going with, and this is the first I hear. I think is the state saying it just happened?
Yes, Judge, I apologize. Paragraph 8, when I say October 3rd, 2019, that's a typographical error. It should be October 3rd, 2023.
Well, this is the first I hear about this. I mean, I read the motion. I just assumed that it is in fact 2019, and I'm not saying that Ms. Reiser's changing dates and all that, but I just want to let the court know. So where we are, Judge, is that, and I'm here on behalf of Mr. Gaither. My client is 28 years of age. He is employed. He has no prior history that I'm aware of. And the last arrest in this involving my client and the alleged victim was in January 10th of 2022. And I'll start out with our position is this, Judge. There are 3 pending cases. I mean, we're not disputing that. He is presumed innocent. However, what I would say is this, Judge. When he gets the second bond or the third bond, the court at the time, I'm not saying it's you, Judge, but whoever the judge that handled the bond.
Me.
Okay. One of the rationale, I'm assuming, is the reason the bond is higher a second or third time is presumably because the court at the time considered the fact that he had a prior arrest. So I'm sure that was a part of the court's thinking as to why it started out with a $2,500 SOR. Of course, this was his first arrest. Then the second time around, and the cash only bond, one of them, Judge, was probably a Superior Court case. But, and so here we are, the last arrest date was in January 2022. And here we are, November of 2023. All of a sudden the state moved, and really their impetus is that the alleged victim is claiming that in August, end of August, that my client was present and he pushed her. And the report is attached, Judge. The report is clear that she did not have any injuries. There were no eyewitnesses. My client was not there. There was nobody else there. And we are in fact disputing that allegation completely, Judge. We are not disputing the fact that he has 3 open cases. His grandmother is present, Judge. She came. He obviously came and has come to court every time, Judge. This case will eventually get resolved one way or another, either by a plea or a trial. I'm not here to address the facts of the open cases, Judge. What I'm here and what I'm stressing to the court is that at this point he's presumed innocent. There's one allegation that was made by the alleged victim from August 2023, but there's been no. And the state could have easily moved to revoke his bond back in 2021 or 2022, but they didn't. And I just, the timing is, here he is out on bond working, and all of a sudden the state moves. Now, I think there's alternatives to this, Judge. The court can impose ankle monitor or house arrest of some sort, as opposed to just simply him being revoked based on an allegation from August of this year, Judge. And that's the court is. I had Ms. Reiser had mentioned that the alleged victim is here. I stand by Ms. Reiser. I know talk to the alleged victim. I'm not here to. I mean, this is not the. I don't want to. There's no need for me to go into unless the court wishes to hear from the alleged victim directly. I have my client's grandmother here if the court wishes to inquire from her. It has nothing to do with the facts of the case. She's just can illustrate a little bit more about what her grandson, what he, he works hard. He provides with his family for his family. I mean, he's never been in any kind of trouble, Judge, absent those issues and problems and crimes that he's accused of involving the same alleged victim, Judge.
I'm a little confused, Mr. Haddad.
Yes, sir.
Are you stipulating that he was with the alleged victim on August 29,
No.
2023?
No.
All right, are you stipulating that he was with the victim in October of 2023?
No, Judge, we're not.
Okay. All right, thank you. We may have, Marshall, where should Mr. Folk sit while the state brings its first witness up? All right. Does the state have a witness that it intends to present? They are disputing that the defendant was never at the scene of the alleged incidences.
Yes, Judge. State calls Ms. Ragland.
And Marshall, she will have to sit here. Yeah.
Judge, do you want her to stand at the
No, she can
podium
stand
or-
right
okay.
here. We have a microphone by the witness chair. We have items in the chair that need to be removed. Thank you. Ma'am, if you please stand up, we need to place you under oath, okay? The deputy marshal's going to place you under oath.
Ms. Ragland, would you please state and spell your name for the record? Kamisha Ragland, CAMESHARAGLAND. Please raise your right hand. Do you swear or affirm that the testimony you provide today is the truth, and the truth, or nothing but the truth, so help you God? I do. Thank you. Go ahead.
All right, let me see. Can we correct that microphone and make sure it's on? It's on, okay. Ms. Carter, let me know if you cannot hear the witness, okay? Ms. Reiser, you may proceed.
Yes, Your Honor. Thank you. Ms. Ragland, can you please state your first and last name for the record?
Kamisha Ragland,
Can you spell your first and last name for the record as well?
CAMESHARAGLAND.
Thank you, Ms. Ragland. Can you tell the court how you know or what your relationship is with the defendant, Nigel Folks?
He's my kid's father.
Okay. How long have you known him?
For about 9 years.
How many children do you share with him?
3.
And how long were you in a relationship with him?
October would have been the 6th year.
October of 2023?
Yes.
Okay. And are you still in a relationship with him? Romantic relationship with him?
I wouldn't say it's romantic, but we are kind of in a relationship. We are.
And do you co-parent with him, with your children?
Yes.
Now, I want to draw your attention to August 29th, 2023. Do you recall that day?
Yes.
Okay. And can you explain to the court what happened that day between you and Mr. Folks, if anything happened?
It was morning. I think it's the incident where I was on my way to work at the airport, and I had to take my oldest son some clothes to the other side of town, and he thought that some of his clothes were in the bag. And so I proceeded to go to the car because I couldn't, at the time, I didn't have the time to go back and forth. I had to be at work. And as I was walking down the stairs, he kind of grabbed the bag. And then the moment he grabbed the bag, I went down the stairs, like I tumbled down the stairs. I didn't hurt myself, but I went down the stairs.
And you said he snatched the bag from your hand,
He grabbed the bag from my hands.
causing you to fall. Okay. And did you call police that day?
I did.
Okay. Was anyone else present during that incident?
His uncle.
And did his uncle do anything to intervene or assist or?
No, he just said that we were doing too much and he drove off.
Okay. And then I want to bring your attention to early October of this year, so 2023. Was there another altercation between you and Mr. Folks?
Yes, there were altercations. There was an altercation.
Okay, can you tell the court, what happened during that altercation?
We were having a regular domestic dispute about things occurring in the household. It got kind of heated. And I think I put my hands in his face, and then when I turned around and walked away, he called me out a name, and I turned around and his fist was in my eye.
Okay, and so did it strike you in the eye?
Yes,
And did it cause visible injury?
yes.
Okay. Your Honor. May I approach the witness?
You may.
And Your Honor, at this time, I am going to show the Ms. Ragland what's marked as State's Exhibit 1, which was shared with defense counsel. Or unless you want to the latest foundation. or-
No, I mean, she can just identify herself.
Okay.
real quick.
And Ms. Ragland, looking at State's Exhibit 1,
We can hear you through that mic.
do you recognize State's Exhibit 1? And how do you recognize that?
As myself.
Okay. And is that a true and accurate depiction of what you look like after that incident that you just testified to involving the defendant?
Okay, please do not just nod your head. You have to say yes or no because
I
the
said
court
yes.
reporter. Oh, okay, thank you.
Your Honor, at this point, I would tender in State's Exhibit 1 for the record.
Any objection, Mr. Haddad?
No, Judge, just to be clear, and this is from October of 2023, this picture, ma'am?
Yes.
All right. No, Judge, not for purposes of this hearing.
State's Exhibit 1 is admitted.
And Your Honor, if I could just give you a copy of that just to
Oh,
show.
I'm so sorry.
I'm sorry,
No,
Ms.
that's
Ragland.
all right. Thank you.
And that just shows, Your Honor, the visible injury in her eye. And Ms. Ragland, just one final question. I know there's 3 open cases, obviously, that you're aware of. So all the incidents that you had just testified to today, did all of that occur after he was released on bond?
Your Honor,
Yes.
Hang on, one question. What's the objection?
Judge, I mean, it's, the court is on, on notice in terms of the chronology. I'm not sure this witness, I mean, she can testify to dates, but it's kind of a moot point. I would draw my objection.
Okay.
If that's all.
That's all I was gonna, yeah.
That's fine.
All right, I don't think I have to say anything after that. What's the
Okay.
next question?
I don't have any further questions at this time, Your
Huh?
Honor.
Your witness across, Mr. Haddad?
Thank you, Judge. If I can remain seated, Judge.
You may.
Ma'am, you had mentioned you have three children with him. Is that correct?
That's correct.
And I think you testified that you two are co-parents with the kids. Is that correct?
Yes, we are.
And is his grandmother in the courtroom?
Yes, she is.
Okay. And do you sometimes drop off the kids, or does she have dealings with these grandkids?
She does.
All right. That's all the questions I have, Judge.
Anything else from the state?
Nothing further, Your Honor.
Ms. Ragland, you may step down, and return to your seat, please. Thank you. Anything else from the state in terms of additional evidence?
No additional evidence, Judge. I think her testimony, what I've proffered, and the photograph evidence of her visible injury, it would be the evidence that we have. I just have argument left.
All right. Mr. Haddad, anything else to present?
No, Judge.
All right, argument. Mr. Haddad, you may,
Your Honor,
whoever wants to go first at this time.
there's nothing additional to add, Judge, other than what I've already brought up to the court. It is clear that just based on her testimony by saying that the co-parent, it is clear that and again, the issue is my client because he's out on bond and he has these restrictions. But the argument that I simply have to the court is that there are alternatives to just revoking his bond, Judge. That's what it boils down to, Judge, and that's it.
All right, Ms. Reiser?
I'll just respond to a couple of things that Mr. Haddad said prior to any testimony. I believe he argued or alleged that his last arrest date was in 2022. I understand that may be the last time that he was arrested on the third case. However, that is not when the violence stopped. He has continued to act in violation of his bond conditions. He has continued to be violent and cause physical harm and injuries to Ms. Ragland. The state has moved to revoke his bond based on this continuous pattern of behavior. Your Honor, and I would argue to the court and contend that the conditions of bond are not stopping him from this continuous behavior. I don't believe that any other conditions that you could place on him is going to prevent further harm to Ms. Ragland. And so I would ask that you revoke his bond in each of his 3 cases. So that's the case ending in 5796, 5846, and 0129.
Thank you.
Oh, yes. And I'm sorry, Judge. And just as an additional general condition of bond, he was alleged to not, or ordered not to violate any of the criminal laws of the state of Georgia or any municipalities, which from his first case, he has done by picking up his 2 other cases and being arrested and violating the law. Once again, I just stand on the position that we're asking you to revoke his bond in all 3 cases.
So I'm not certain from the evidence that's been presented so far, how is it that the defendant was at 3200 Cushman Circle on August 29, 2023? All we know is that the victim was at the premises, and next thing you know, her bag was being allegedly taken by the defendant. I'm not certain under what circumstances Mr. Folks was in the house, whether he entered without a permission or whether he was there with permission. I have no idea. But Mr. Folks, it took 3 cases and 3 orders where you were expressly told to stay 200 yards away from 3200 Cushman Circle, and you were to have stayed 200 yards away from Kamisha Ragland and 200 yards away from the children that you share with Kamisha Ragland. The only order that allows you to have contact with the children would have been a superior court order if you had filed a legitimation action. And I'm reading my own order from January 11th, 2022, when you and I were on Zoom, and I expressly told you that you're given a $3,000 cash bond because of my concerns of your 2 prior cases. I'm revoking your bond in its entirety. You do not get a bond because of your blatant disregard of the court's order. You'll be remanded to the Fulton County Jail and remain there until your trial date. Your case is going to be reset for a jury trial. And yes, Mr. Haddad?
Your Honor, on behalf of Mr. Gaither, I was going to request to set these cases for jury trial, if at all possible, in light of the court's ruling to revoke his bond, if we can have it set for the closest trial calendar, which would be, I think, in January. I understand, but just because he's going to be incarcerated, Judge. I mean,
Right.
So
And
that's my
we're
request.
going to reset it for the jury trial calendar for cases in which individuals are at Fulton County Jail.
Thank you.
So we will send you notice.
Thank you, Judge.
All right, thank you. Marshals, I'm going to let you address that. And Ms. Reiser, please submit a proposed bond order.
Yes, Your Honor. And just to clarify, is that on all 3 cases?
All 3 cases,
Yes,
no
sure.
bond, no contact with the alleged victim, no contact with the children in question, no alcohol, no drugs, no weapons, and stay away from 3200 Cushman Circle.
Yes, Judge.
All right.
And with that, Your Honor, that concludes my business. May I please be excused?
Yes, you may. Thank
And
you.
may Ms. Ragland please be excused?
Yes.
Thank you.
Judge, may I also be excused? That was the
Yes,
only
Ms.
case I was
Carter,
here for.
I was going to say, first of all, if you'll just give me a moment. Are there any cases in the courtroom that need the services of a court reporter in lieu of a recorded Zoom proceeding? Are there any cases on Zoom that would need the services of a court reporter in addition to the recorded proceedings? All right, Ms. Carter, I'm hearing cricket, so I am going to release you. You're free to go. Thank you very much for accommodating us this afternoon.
Thank you, Judge.
All right. If you hear your name called, please let me know if you are present and who's your attorney and whether you're ready to proceed with the plea. Thank you. Doratus Aaron.
Judge, this is my case. We intend to pre-try it and we'll report back.
Marcia Anariva Ramos. Mr. Mazlum.
Good afternoon, Judge.
Good afternoon.
She's present on Zoom as well. Judge, I don't believe we're going to be able to resolve this case with a plea.
All right. Has the case been arraigned?
I'll have to look, Judge. I don't know that it has.
Whenever I hear that means I click on the case. Okay, just a minute, Mr. Mazlum. You guys okay? Okay.
Judge, I'm the second attorney on the case, so I'm not really aware of whether it's been arraigned or not.
I know, I'm just looking it up, sir. Yes, a waiver of arraignment was filed on February 4th, 2022. The case is going to be reset for a jury trial. And unless you're opting for a bench trial.
No, Judge, jury trial's fine.
Okay, you will receive notice of the jury trial. I know my January calendar is already full, so you will get another notice for another term, all right?
All right, thank you, Judge. That completes my business. May we be excused?
Yes, thank you.
Have a great day.
You too.
Thank you.
And we will issue a case management order in position 2. Centrisa Cobb, Ms. Rosenhuber?
Yes, Judge, this is my case. Ms. Cobb, Ms. Cobb is present. We'll pre-try and report
Where
back.
is she?
She's right in the front, Judge.
All right, thank you. Positions 4, 5, and 6 are reset for a jury trial. And Ms. Reiser will send me the bond order, and Mr. Randolph will do a case management order for all 3 cases, please. All right, sir? Okay. Position 7, Amber Garcia has already been addressed. So, and that's being reset for a jury trial.
That's correct.
Position 8, Johnny Gilbert, Johnny Edward, Mr. Spisman. Good afternoon, sir.
Hey, Judge, good afternoon. I have talked to Ms. Reisner about that case. She does not have the video in that matter yet. We agreed with the court's permission of a mutual reset. We have motions pending, but we think we might be able to get it resolved.
I'm going to reset you to the motions calendar, which is going to be January 19th. That's going to be in person at 9 a.m. January 19th, 2024. It's going to be at 9 a.m. in courtroom G33.
Thank you, Judge.
Thank you. You're free to go.
I have one more, Your Honor. I'll hang.
Oh, you have one more? Okay. Linnell Green. Linnell Sebastian Green. Mr. Green's present. Who's your attorney, sir? Have you applied for the public defender's office?
Yes, I don't.
Did you hire one?
I did, 2 years ago. Was happened.
Okay.
That lawyer is out of practice as of August.
Did you hire one after August? So what do you plan to do now? I'm going to put you down for pre-trial, which means you talk to the prosecutor if you want to, with regards to how you want to resolve your case. Whether you want to go to trial or whether you want to consider a pre-trial offer.
And Your Honor, before this court hearing, we did speak this afternoon.
All right, thank you. Rebecca Hart, Kevin Fisher.
Hi, Judge. That case has been put in diversion. So we were told we were excused, but I'm here on another case.
Okay.
Well, I'm here anyway.
Has this got a update for diversion?
Yes.
Ms. Allen, do you have an update for diversion?
It was just placed in diversion about 2 weeks ago, Your Honor. We can get it reset for compliance.
All right, I can do January 5th, 9 a.m. It can be done via Zoom, and it's just a compliance update.
As much as I love being here in person, Judge, Zoom is just fine.
Mr. Fisher, just because of that, I mean, okay, that's fine, right? All right, you got one more case, right? Okay, January for Rebecca Hart is January 5th, 9 a.m. via Zoom compliance update. Amanda Hood, Anyone from PD's office representing Amanda Hood?
Yeah, she retained Matt Hirsch, Judge. She filed an entry.
Judge, I'm here.
There it is.
Oh, there you are, sir. All right, good afternoon. And Mr. Hirsch, how are we proceeding on Ms. Hood?
Ms. Hood got a diversion referral today. We signed the paperwork. I handed it to Ms. Kathia. I didn't hand it. I emailed it to her right before court.
Okay. So I don't know if she's already been admitted into diversion since it was just submitted. I'm gonna reset it to January 5th, 9 a.m. via Zoom on status for if she's admitted to diversion, y'all will give me an update.
Thank you, Judge. She'll definitely be admitted. Should I just notify the court, or do you want us to?
Either you or Miss Hood can show up on Zoom and just let us know how she's getting along with diversion.
Okay, that's fine.
All right.
We just
If
need to.
that's your only case, you're free to go as well as Amanda Hood.
Thank you, Judge.
All right. Jeremiah Jackson? Jeremiah Jackson? All right. And who's your attorney? Have you applied? Do you qualify? Okay. You need to pre-try your case. You need to speak to the PD first to see what's going on with your application. And then after that, you can decide whether you want to hire an attorney or speak directly with the prosecutor. But you can't leave until that's resolved. Halflin, Jean Francois, Mr. Gaither's case. All right, he's present.
Judge, make an announcement for Mr. Gaither, on both cases, to set it on a jury trial calendar, Judge.
All right, have these cases been arraigned?
If not, I'll have Mr. Gaither file a waiver of arraignment, or I can enter a plea of not guilty on his behalf on both
Right,
cases,
sir.
Judge.
Just give me, I can only look it up as fast as Odyssey goes. I don't see an arraignment, so please file a waiver of arraignment in both.
That's fine, Judge.
Okay, case management orders will issue and the case is reset for a jury trial.
Thank you, Judge. And
Mr. Jean-Francois, you need to make sure you keep in communication with your attorney, Frank Gaither, and your case is reset for a jury trial. Please be prepared. You're free to go. And then I have position 15, Woodland John Baptiste, who is going to take a plea today. Is that
That's right,
correct,
Judge. You
Mrs.
should have all
Bismarck?
the, yes, right, Judge. You should have all the paperwork ready when you are.
I do, thank you.
Thanks.
Samuel Johnson,
Mr. Johnson is present, Judge. If we could pre-try and report back, please.
all right. Folks, when the attorneys announce that they're going to pre-try, or when I ask that the case be pre-tried, that means the litigants or the litigant's attorney is going to speak to the prosecutor to see if they can come up with a resolution. So if we say pre-try, you cannot leave the courtroom and or you cannot leave the Zoom, okay? Samia Langston, I've got that case ready for a plea today.
Good afternoon, Judge. I apologize for interrupting you. That's going to be my case. Catrice Helen from the Public Defender's Office.
All right, that's the plea paperwork. Thank you so much.
Thank you, Judge.
I have Joseph Lanier with William Toller. Joseph Robert Lanier, are you present? Joseph Robert Lanier is not present. I see that he's got a pending application for DUI court. Miss Allen or Miss Githia, do you have any reports on that?
My understanding is that that was an option. I don't know that the defendant and counsel actually moved forward with that. Would love more information. I requested more information myself.
Well, it'd be helpful if someone showed up to let us know, but I have no idea. So I'm going to mark that as an absence from this calendar.
I think Mr. Fuller was requesting a Zoom link in the communication with me.
Is
about additional offers.
Is attorney William Toller on Zoom? All right, I'm hearing cricket. So you all decide what you want to do at the next calendar call.
If we send a Zoom link, we have to.
Oh, definitely. Yeah.
I think he was asking for one.
Okay. Omar Lozoyo Dominguez, Mrs. Fisman? Oh, Mr. Fisher, excuse me.
I'm here as well.
We are here, we are ready to go forward on a plea when you're ready, Judge.
Do you have the plea paperwork already submitted
We have already submitted to the court.
by DocuSign?
We did actually on paper and the court has it.
Mr. Randall, do okay, I'll look and see. I didn't see any in my stack. Oh, here it is at the top. Okay. Got it now. Thank you.
Thank you, Judge.
Okay. Shasta Moon, Ms. Rosenhuber?
Yes, Judge, that's my case. Ms. Moon is
Moon
present.
is present.
I believe that we'll be able to have that worked out. We just need to free try it.
Okay. This is going to be pre-try. Angelina Nava. Angelina Nava. Ms. Nava is present.
And Judge, that's going to be my case. Catrice Helen from the Public Defender's Office. We've already entered in and submitted that DocuSign. We're just waiting for the court to take that plea today.
Okay, I hope I have that document. I didn't see it, but then again.
I can resend it to Mr. Randolph or.
Please do, please.
Thank you, Judge.
Diana Natifu.
Good afternoon, Judge Ray Well here. That case is already signed up on DocuSign. We're ready for approval.
Okay, thank you.
Thanks.
Manuela Rivera.
Judge from that committee, Mr. Rivera, he's present. We're signed up on DocuSign for officially as well. Judge.
All right, thank you. Neil Salter, Ms. Watson Cafe.
Good afternoon, Your Honor. I have reached out to Mr. Salter.
Neil Salter on Zoom. Your attorneys in the courtroom. Do you want to try calling him again?
The phone number that we tried last week, the phone number that we have is not a good number. We've emailed, he has responded in the past, but I attached his.
All right, well, you're welcome to wait to see whether he shows up when I do my next calendar call. Raven Sheriff.
Your Honor, Elizabeth Rainwater with Georgia Justice Project for Raven Sheriff. Raven is here virtually along with Pad Care Navigator Darcy as well. And I believe this should be a negotiated plea, and we submitted that paperwork yesterday to the court.
All right, got it. Thank you so much. Anthony Smith, Anthony Lamar Smith.
Yes, Judge, that's my case.
Yes, I'm here.
Mr. Smith is over Zoom. That we are going to request a jury trial for him.
All right. By any chance, you know if this has been
Don't, Judge. I really need to start checking that.
okay.
Sorry about that. But
It's
if
all right.
not, I'll file a waiver.
Anthony Smith.
Yes, ma'am.
All right, so I'm just wondering whether you've entered a not guilty plea in the past. So, or wait, it looks like it was arraigned on December 20th, 2021. So we're going to generate a case management order. The case is going to be reset for a jury trial.
Thank you, Judge.
All right, Mr. Smith, do keep in touch with your attorney, Ms. Rosenhuber, and we will see you in for trial next year.
Okay, thank you.
Thank you.
Perfect. Have a good day.
You too. Maggie, Elsie, SZUTZ, Zutz, Zutz.
I think we previously reset, Your Honor, this week. I believe the defense filed a conflict, but ultimately, we requested together that it be reset to December the 7th in person.
Okay.
Just for.
Okay, we'll see, Mr. Mitnick on December 7th. Andrew Tolliver. Andrew Tolliver. All right, Mr. Tolliver, who's your attorney?
I called the public defender office. They told me I had to be appointed one by you. So.
All right, so does he need conflict?
We'll look that up right now.
Okay, have a seat, Mr. Tolliver. You'll need to pre-try your case either with the PD's office, or they may have to what we call conflict out and get a conflict counsel for you. And if you choose to represent yourself, you can speak directly with the prosecutor. But right now, just hold tight. You've got your case down as pre-trial. Elder Trejo.
Trejo is here. The state has offered us a DUI court plea, which we are going to accept, but we're applying right now to DUI court. We'll have an application into them today.
Who's the prosecutor?
So that's my case. I spoke to co-counsel as well today and sent a few emails this week regarding this case. The previous offer in this case was one option as a DUI court option and one option that was without DUI court, and we just haven't heard back. So it's at this point, and I would ask for some guidance. Is it typical that at a final plea, the defense now says they're interested in entertaining application to DUI court, or expected that to have already happened?
Let me check my magic balls because that thing is so inconsistent with me. But sir, if you're planning to apply for a DUI court, and if your client is admitted, you'll give us an update at the next court appearance.
Yes,
But if not, then y'all can either consider a plea or decide. You can either, take a plea at the next calendar or just announce that you're ready for the trial.
Thank you, Your Honor.
And
Right.
what's the process that a defense attorney and defendant go through at the point if they want to apply for DUI?
They have to go to the DUI court administrator. I think it was Judge Edlines last time I checked, or is it now Judge Taylor? I cannot recall.
I believe it's Judge Edlines.
Okay. So Judge Susan Edline was the one administering the DUI court. Are you familiar with that, sir?
Yes, Your Honor, and just from their website, I saw that they can fill out an application, send it to their administrator, which we will do before we leave the building.
Okay. You can give us a seminar on it one day also. All right, appreciate it. Thank you.
Just to be clear, an offer that says one or the other for someone who's a candidate, it is not the onus of the prosecutor at that point to then connect the defendant and his attorney.
You have no requirements. Okay. Case is reset to my next final plea calendar, which is going to be January 5th. And it's going to be at 1:30 p.m. Same time, same place next year. Happy New Year. Thank you. This is going to be for a final plea or a DUI court update. Terrell Williams, Mr. Arrington. There you are, sir. Good afternoon. Yes, sir.
We have negotiated plea.
All right, sir. Do you have the DocuSign documents all submitted and signed off? And well, let me rephrase the question. Have you and your client reviewed the electronic documents, DocuSign them, and forward them accordingly? Are you doing it right now?
I am, Your Honor. It's not complete. I'm in the process.
Okay, just let us know when you're ready. Okay, thank you. Sean Montgomery Young, Jeffrey Dickerson.
Good afternoon.
Hi, Ms. Angeles. How are you?
Kimberly Seth appearing for Jeff Dickerson on behalf of Mr. Young. They have DocuSigned everything. I was able to see the confirmation of that. And Mr. Young is out of state, so he's appearing.
He's on Zoom, yes. Okay. So for those of you who are on Zoom, hang tight if you are waiting to take a plea, as well as those in the courtroom. Okay. And that was my final plea calendar. This is my show cause calendar. I have Shakershan McHenry. Shakertian McHenry or McHenry. Might be a typo in the last spelling. No? All right, this was the show cause for bench warrant. Michael Petway.
Good afternoon, Judge. Mr. Petway is going to be my cases. He's positions 2 and 3. And I just want to make sure my video is working. I apologize for that, Judge.
No, your video is not working. I see Benjamin Petway on Zoom. He was supposed to show up in person for these show cause calendars.
I do have some information, Judge. For the first failure to appear, Mr. Petway was arrested, and I'm still trying to fix my video. He was arrested and was incarcerated in the Smyrna County Jail. His dad tried to give him the Zoom link for Fulton County, but Smyrna would not allow him to join that Zoom conference for his court date. So on this court date, Judge, he had actually reached out to a previous public defender that had represented him, Judge. I'm still trying to get that video to come on. Represented him, Judge, and let him know that he was actually in the hospital currently. That's where he's at, right? Or not able to be in the court because of a medical condition that he had been at the hospital regarding, Judge. That medical condition is Meniere's. It causes intense vomiting, intense vertigo, hard issues of standing. Mr. Petway, if he does have to leave, it's because of those things that he's suffering from, Judge. So I wanted to give information that I have currently for the first failure to appear. He was in Smyrna County Jail. For
All right,
this,
so first of all, Ms. Helen, if you remove the background filter on your video, that would help matters because you keep fading into this really pretty off. Okay, there we go. Now, all right. The other thing is if you have the documents of the incarceration at the Smyrna City Jail, if you can forward that to Miss Allen in the courtroom. And then with regards to his current, I don't know whether you're trying to describe an inpatient situation or a medical situation. If you have any supporting documents, you can also forward that to Miss Anna Allen, and she will take it up accordingly. But I see Mr. Petway present on Zoom. I've noted that, and we will wait to hear about that.
Your Honor, I had spoken with Ms. Helen about this, so she can send those documents to me.
Oh, I see. Okay, Miss Helen, redirect that to Miss Sarita Gathia.
and Mr. Petway, I've given you my email address. If you do have any of that documentation, if you could try to get that to me so that I can give that to the solicitor while we're here in court, okay?
Yes, ma'am. I don't have a scanner. It's printed paperwork from the hospital, from the emergency department. I can try and get to a scanner hopefully within the next day.
No, it has to be done today, sir. It has to be done today. Otherwise, I'm issuing a warrant.
Take a picture on the phone.
All right, Miss Helen, if you want to call him and try to resolve that.
Sure, Judge. I have his number. I can speak to him.
Okay. Ladies and gentlemen, some of these cases are going to be pre-tried. Some of these cases are ready for a plea. Sean Young.
Yes, Your Honor. Good afternoon.
Good afternoon. Okay. All right, this is 20 CR 002710C, State versus Sean Montgomery Young, accused of DUI under the influence of alcohol less safe, failure to obey a stop sign, failure to maintain lane or improper lane change, failure to have license on person or having an expired license. 5 charges. Mr. Young is appearing via Zoom and his attorney, Ms. Sluss, is in the courtroom. Mr. Young has been advised of his rights. May I place you under oath for purposes of the plea?
Yes, you may.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
All right. Miss Allen? Yep. All right. I understand that he's proceeding on 1 count of DUI less safe and the remaining charges are being null pros. Is that correct?
Yes, Your Honor.
Okay. Please let me know what's the offer.
The offer in this case is 12 months to serve 24 hours, credit for time served 24 hours, balance of probation, a $300 fine, 40 hours of community service, complete alcohol and drug evaluation, follow through with any treatment recommendation, a risk reduction panel, and 1 fixed impact panel. As you said before, the remaining offenses will be dismissed.
That's it?
Does the attorney and Mr. Young stipulate to the facts?
We so stipulate.
Venue and ID as well?
Excuse me?
Stipulate to the venue and ID as well?
Yes, on behalf of Jeff Dickerson, I I stipulate to venue.
All right, Mr. Young, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
I have, yes,
Are you satisfied with the legal services you've received?
yes.
And is anyone forcing you or inducing you to take a plea today?
No, Your Honor.
And Mr. Young, if you decide to enter this guilty plea today, you would have to give up your constitutional right to a trial, to confront your accuser, challenge the evidence of witnesses brought before you, as well as to have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I am and I understand.
I'm sorry?
I said I am and I understand, yes.
Okay. And has it been explained to you that you do not have a right to appeal this sentence?
Yes, it has.
All right. And has it been explained to you that entering a guilty plea to a DUI will have impact on your license, will have an impact on any professional licenses you may have, any open cases you may have, as well as your residency if applicable?
I understand.
All right. And how do you plead to one count of DUI less safe?
Guilty.
Your sentence is going to be 12 months to serve 1 day, credit for time served 1 day. The remainder of the time will be on probation, which would be 11 months and 29 odd days. You will report to the probation office next Thursday before 3 p.m. That's before 3 on November 9th, 2023.
Wait 1 second. Your
I'm
Honor.
sorry.
you're-
I just said yes, and he's out of state, and as I understand it from Mr. Dickerson, there was an agreement to virtually report.
Correct.
If
I didn't hear that. This is the first time. The attorney is from my attorney's office, but it's the first time I've spoken to her. I guess didn't understand the entirety of the.
Are those
the-
reading glasses that you're wearing?
Say it again, man.
Are you those reading glasses that you're wearing?
Are they prescription? They have their prescription for the sun.
Are you in the sun right now?
I am not. I'm in a heavy light, but I can take them off. It's not a problem. I have a lot of light where I am. No problem. I'm here for you.
All right. Miss Allen, where does he live, Miss Luss?
New Jersey, I believe.
Does he live there or is he just there temporarily?
I understood that he lived there. Yeah.
All right. Does the state have any objection to telephonic reporting?
Is that something that's available?
Yes.
I don't believe it was agreed to beforehand, but we do not have a problem with that, Your Honor.
All right. I'll allow for telephonic reporting. So your first contact with the Fulton County Probation Office has to be by phone before 3 p.m. next Thursday, November 9th.
Okay, I guess I can get the correspondence for that from my attorney.
Yes, and in fact, we are going to email Miss Luss, we're going to email you the probation form, which he has to fill out.
Sure, I might do that before I leave, if that's possible.
Yeah, Mr. Randall will make sure that's sent to you. He needs to fill it out and submit it back to us.
Okay.
All right.
Thank you.
And do you have a New Jersey driver's license?
My understanding is there wasn't a probation though. I don't understand.
Okay.
I'm serious. Serious, Your Honor. I didn't.
All right, please be quiet.
Mr.
All right.
Young, we will talk off camera.
Yeah. I'm going to put a hold on this, and Mr. Young doesn't seem to have a grasp of the terms that I see on paper. Mr. Young, Miss Luss or Mr. Dickerson is going to call you, and then we will address your plea later. Mr. Fisher, who was your client? Repeat again, sorry. Okay.
We are ready when you are, Judge.
I am. You can come up to the podium.
Thank you.
This way, this way.
Thank you.
Thank you.
Now, what kind of order do you need? Okay. I thought there was really an outstanding warrant. Oh, no. Miss Allen, could you please approach? Yeah. This one's okay, right? Yeah. Okay. Ms. Howell, if you can contact Ms. Reiser, I need the order revoking bond control. What time is it? Yeah, we need it like 5 minutes ago.
Yes.
Yeah, oh, well, 5 minutes ago at least. Thank you.
Thank you so much.
Okay. We have position 19 on our final plea calendar, case 21 CR 0039378, State versus Omar Lozoyo Dominguez. I butchered your name?
Yes, no, just
No,
fine, Your Honor.
okay. Mr. Lozoyo Dominguez is accused of DUI, driving under the influence of alcohol less safe, and failure to maintain lane from a January 18th, 2020 incident. Mr. Lozoyo, you've been advised of your right to remain silent. Your attorney is Mr. Fisher. And you are, this is going to be a negotiated plea hearing. May I place you under oath?
Yes.
The other way.
Sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Allen, what are the terms for Mr. Lozoyo Dominguez?
Your Honor, we're reducing this DUI less safe to reckless driving. The offer in this case is 12 months, served 1 day, credit 1 day, balance probated, 40 hours community service, $500 fine, alcohol drug evaluation and follow any treatment recommended. The driving panel as well as 1 victim impact panel, risk reduction, I think it's called.
That's right.
And then for the failure to maintain a 12-month probationary period that's consecutive to the first period, so 24 entire for both. And this can be non-reporting after the conditions in count 1 have been met. So 24-month probationary period and 12 months for each count, but it can be non-reporting once the count 1 condition.
Understood.
Mr. Fisher, do you and your client stipulate to the facts and evidence?
Yes.
Venue and ID as well?
Do you
Stipulate to the venue and
Yeah.
ID of your
Yes,
client?
yes.
Thank you.
Mr. Lozoyo, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And is anyone forcing you or inducing you to take this plea today?
No, Your Honor.
Has it been explained to you that if you decide to accept this plea, this will close the case out? You will not have the right to appeal this case. You will also not be able to go back to court and have a trial in front of a judge or jury to be able to confront your accuser, challenge the evidence or the witnesses brought before you, present any mitigating factors or defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
All right, since this is not a DUI, it's hopefully not going to have an impact on your driver's license, but pleading guilty will add points to your driver's history.
We would like to request the court if we could plead no contest to both charges.
Does the state know if he qualifies?
No, wasn't discussed with us.
Your Honor, I discussed it with Ms. Reiser before Madam Prosecutor arrived, and she did say the state would object to it, but I did say I was going to ask for it.
Does he qualify?
I believe he does.
Well, believe is one thing, but do you have his driver's history to show?
I don't have his driver's history in front of me, Judge.
Okay. I'll accept a NOLO, but as your attorney will explain to you that if you have entered a no contest in the last 5 years, then the Department of Public Safety will reject the NOLO and convert it automatically to a guilty, and then add that to your points to your driving history.
Okay, I understand, Your Honor.
That's fine, Judge.
So you are good with that?
Yes.
Okay. So I just changed all the guilties that you have filled out to NOLO.
Thank you,
Okay.
Judge.
Thank you for making me do that work. Okay. All right. So how are you pleading to reckless driving and failure to maintain lane?
No contest, Your Honor.
Your sentence for the reckless driving is 12 months to serve 1 day, credit for time served 1 day, you'll be on probation. You report to probation at 132 Mitchell Street, which was going to be next Thursday before 3 p.m. You would need to fill out the probation intake form before you leave the courtroom. While you're on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. The food banks, Salvation Army, Goodwill, places like that are okay. You have a $500 fine plus court costs and surcharges, as well as your probation fees. You report, and while you're on probation, you will complete an alcohol and drug evaluation and submit yourself to any treatment that's required at your expense, complete a risk reduction program, and attend one victim impact panel. All right. For failure to maintain lane, you will be on probation consecutively. So that means you'll be on probation for up to 24 months, less 1 day. All right. If you complete all the conditions for the reckless driving, your probation may convert to non-reporting. Do you have any questions?
No, Your Honor.
Okay. Mr. Fisher, if your client will just sign where I put the X's right here. There's one right here and one right here, all right? And if you have a seat, the probation form will be given. You won't have to stay here for that because once he completes it, we'll give him a copy. His report date's next Thursday.
Thank you, Judge. I'd like to walk him through everything, make sure there's no questions.
Okay, thank you.
Thank you, Judge, for your time.
All right, Mr. Spisman, remind me again, who's your client?
Thank you, Judge. It's Woodland Jean-Baptiste.
Okay. Mr. Randall, this is for this gentleman. Oh, I'm sorry. Mr. Randall has to file the order and then you're good to go once you get a copy of it. Okay. We good?
We're good, Your Honor. I just want to get a copy of the disposition before I leave, if that's possible.
Okay, have a seat and they'll
Thank
get
you.
one for you. All right. Okay, Woodland Jean-Baptiste is somewhere calendar. Can you give me the position number?
15.
15. Okay.
And Judge, I have a few announcements, just whenever the court's ready for me.
All right, just a moment. All right, I see Mr. Jean-Baptiste Woodland on Zoom next to counsel, Mrs. Spisman. This is State versus Jean-Baptiste 21 CR 5345A. Mr. Jean-Baptiste is accused of DUI, alcohol, less safe, and improper lane change from September 28, 2019. Mr. Jean-Baptiste, you've been advised of your right to remain silent and your counsel is with you, both of you appearing virtually. For purposes of the plea, Mr. Baptiste, may I place you under oath?
Yes, Your Honor.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, thank you. Miss Allen, is this your case?
That's mine, Your Honor.
Oh, is it Miss Githia?
Yes.
We're very excited, obviously.
All right, well, why don't I give you a break and Miss Githia, you get set to go.
Yes, Your Honor. The DUI alcohol less safe is to be amended to reckless driving, and it is 12 months to serve 24 hours, credit for time served 24 hours, the balance probated, a $300 fine, 40 hours of community service, to do an alcohol drug evaluation and any required treatment, a risk reduction program, and attend one victim impact panel. The improper lane change will be null process. The defense stipulates to the facts, venue, and ID.
So stipulated, Judge.
Thank you. Mr. Baptiste, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your legal services?
Yes, Your Honor.
And is anyone forcing you or inducing you to take this plea offer today?
No, Your Honor.
Has it been explained to you that if you take this offer, that you will not have a trial in a court of law? You will not have the opportunity to be in a court with your attorney, to confront your accuser, challenge the evidence and witnesses brought before you, present any mitigating factors or defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And has it been explained to you that pleading guilty to the current charges will add points to your driver's history?
Yes, Your Honor.
Are you still willing to move forward voluntarily and knowingly?
Yes.
How do you plead to one count of reckless driving? Mr. Jean-Baptiste, how do you plead to one count of reckless driving?
Guilty, Your Honor.
Your sentence is 12 months to serve 1 day, credit for time served 1 day. The remainder of the time will be on probation. I don't want to go through this again. Mr. Spisman, is your client in Atlanta and will report to the probation office downtown?
Ms. Jean-Baptiste, you're in Atlanta, correct?
Yes, Dunwoody area. Yes, sir.
Yes,
Okay.
Judge, he will.
You must report to the probation office at 132 Mitchell Street in downtown Atlanta on Thursday, November 9th, 2023, before 3 p.m. While on probation, you will pay a $300 fine plus court costs and surcharges, complete 40 hours of community service at any nonprofit agency which is not a school and not a church. You will also submit to an alcohol and drug evaluation and submit yourself to any treatment if required. Complete a risk reduction program and attend one victim impact panel. Any objection to non-reporting? Ms. Gutierrez?
No objection, Your Honor.
Mr. Baptiste, if you complete these conditions, then your probation will be non-reporting. Any questions?
No, Your Honor.
All right, Mr. Spisman, we good?
We good, Judge. Thank you. Have a great weekend.
You too. He needs to fill out the probation information. So if you will, please hold, or have you done so?
I don't think that was, they didn't send us the probation information. If Mr. I think is it Rudolph? I'm sorry, Randolph can send it to us. I'll get it filled out and returned.
All right, if you please hold, get that information and then you can send it back to Mr. Randolph anytime before 4 o'clock today, okay?
All right. Thank you.
Thank you.
Mr. Randolph, I'll email you separately to request that so you can get it. Thank you.
Miss Rainwater, who was your client?
Raven Sheriff, Your Honor.
Do I have the paperwork yet?
I believe you did, so we went thought yesterday.
Yes.
Got it, okay. And Mr. Lale, who was your client?
Ditful, Diana Ditful.
Okay. Okay, you're on deck, sir. Okay. All right, Raven Sheriff is on Zoom with her counsel, Ms. Rainwater. Okay.
Yes, Your Honor, and just for the court's clarification, present is also Policing Alternatives and Diversion Care Navigator Darcy as well, here in support for Raven Sheriff.
I appreciate that, thank you. This is case 21 CR 4031F, State versus Raven Sheriff, accused of battery from July 21st, 2021. In Fulton County, Georgia. Ms. Sheriff, you've been advised of your right to remain silent, and your attorney is Ms. Elizabeth Rainwater. For purposes of this plea hearing, may I place you under oath? Thank you.
Yes.
Solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you. You may put your hand down. And this was position 25. That's Ms. Allen's case. Ms. Allen, what's the recommendation for Ms. Sheriff?
The offer in this case, Your Honor, is a 12-month probationary sentence to serve 5 days, you get credit for the 5 days already served. Balance of that 12 patient, 40 hours.
Hang on 1 second. Miss Sheriff, is there somebody else who can take the child?
1 second.
Okay.
So sorry.
That's all right.
So 40 hours of community service, no further violent contact with Mallory Bellino, alcohol, drug, and evaluation, and follow any recommendations for treatment, no drugs, alcohol, or weapons. Once the conditions are met, specifically the 40 hours of community service and the evaluation, probation can be suspended.
Okay. And could you give me the name of the victim again?
Mallory, Mallory, Bellino, Bellino.
INO. Okay.
Your Honor. I apologize, Your Honor. I just wanted to make sure I heard correctly. On the plea form that we sent into the court, and based on communications with ASG Jacob Stevens, who I understand is not in this case, I believe it was a 12-month, and I apologize if I'm repeating what was just said. I just want to make sure it was 12-month sentence, 5 days serve, and the remainder probated with 40 hours of community service. And all of that would be suspended upon completion of Miss Raven's treatment at the Mary Hall Freedom Village, where she is right now, and she would need to get an independent alcohol drug evaluation after completion of the program.
Okay, so once she completes the independent
treatment
evaluation
program
that she needs after her program and does 40 hours community service, it looks like all of the conditions will be met and the probation was suspended.
The 40 hours of community service was also suspended upon completion of the program, and then getting an independent drug evaluation. Mr. Stevens and I had discussed what the most clear phrasing would be, and it seems that we did not come to a good resolution on that phrasing. I apologize, Your Honor.
Let me just read what's on the plea sheet and then you see what it says.
Yes.
So 12 months to serve 5 days, credit for time served 5 days, correct?
Yeah, yes, it's actually, Judge, she technically has 1 day of credit for time served, so she would have to serve 4 if she did not complete the program.
Okay, so let me 12 months to serve 5 days, credit for time served 1 day.
Yes, Judge.
So she has 2 actual days to serve at the jail.
So all of this, Your Honor, is suspended upon completion of the program. Mr. ASG Stevens was clear that the probation, the time to serve, and the community service would not be, Ms. Raven would not be serving that unless she did not complete her treatment program and did not get an independent alcohol drug evaluation. And she is still in that treatment program right now.
Is the independent alcohol and drug evaluation suspended if she finishes the treatment program?
No, it is not. She has to get a drug evaluation after completion of the program, Mary Hall Freedom Village.
It sounds like the conditions on this case, Your Honor, are a 12-month probationary period, and to serve 4 days.
No.
I apologize, Judge. Her mic's not on. We can't hear the state at all.
Yeah, Miss Allen, if you could bring that microphone towards you and turn it on, thank you. It looks like the light went back to red. Okay, and just, sorry, and bring that mic closer to you. There we go.
Can you hear me now?
Yeah. Oh my goodness.
So it looks like the focus of the offer and the agreement was to make sure this young lady completes the Mary Falk Freedom Village program.
That's right.
She has to serve 4 days in jail and complete 40 hours of community service, or complete the independent treatment program, plus do an independent alcohol and drug evaluation.
Yes, Your Honor. That was my understanding with ASG Stevens.
Sounds good.
Okay. May we move on, Ms. Rainwater?
Yes, Judge, I apologize.
I quite frankly forgot where I left off. So I think the point we left off with the state confirming that it's going to be a 12-month sentence to serve 5 days, credit for time served 1 day, to do 40 hours of community service. The jail time and the community service are suspended if Miss Sheriff completes the independent treatment program, plus completes an independent alcohol and drug evaluation.
Yes, Judge, and the probation should be suspended as well.
Doesn't say that on your plea sheet.
Okay,
I can make it non-reporting, but I'm not going to suspend it.
yes, non-reporting, Your Honor, we would appreciate that.
And at all times, she's to have no violent contact with Mallory Bellino.
Yes, Judge.
So, Ms. Rainwater, do you stipulate to the factual basis, venue, and ID?
Yes, Judge.
And does your client agree to these terms?
Yes, Judge, my client agrees to the term.
All right. And before I move on to the narrative, is your client able to report to probation in person?
She is not, Judge. She will be at an inpatient treatment program. And I apologize again. My understanding was she would not have to report while she is in the program.
Any objection to telephonic reporting, Ms. Allen?
No, Your Honor.
Ms. Sheriff, have you consumed any medication or alcohol recently? Uh-oh, Raven Sheriff is frozen.
Your Honor, I can try to call her just to see if we can get, oh, she messaged me and said my screen froze.
Okay, we'll hold off on that. I'll get back to you.
Okay.
Mr. Leal?
Ma'am.
All right, why don't you and your client come up to the podium? Ms. Rosenhuber, what were your announcements?
Yes, Judge, beginning with position number 1, Mr. Daradu Aaron, we're requesting a jury trial in that case.
All right, the rate is Aaron, and he's present.
Correct.
Okay, so has this case been arraigned by any chance? Are you?
I really need to keep checking that, Judge. I'm not sure.
Your Honor, position 18's attorney, I think, has joined the Zoom, Mr. William Toller.
Okay, I'll be with him shortly. Thank you.
I'll check on whether that's been arraigned. If not, Judge, I will happily file.
Let me see. He waived arraignment on September 27, 2021. The case management will issue for position 1, and the case is reset for a jury trial. Mr. Aaron, your case is going to be scheduled for a jury trial. Make sure you come back to court in person, prepared to go to trial. And if you change your address, let us know first thing out, okay? If you have any questions, you can speak to your attorney, and you're free to go.
Hey, Judge.
You good?
Position.
Any other announcements?
Yes, Judge. Position number 20, Ms. Shasta Moon, she's present. The state has agreed to null pros that case.
I've submitted that order, Your Honor.
All right, thank you. Position 20. Shasta Moon?
Yes.
All right, your case is dismissed. You're free to go.
And one final announcement, Judge.
Do you have any other announcements?
Yes, Judge, just one. Position 16, Mr. Samuel Johnson. If we could get the court's next available motions calendar, I believe that we should be able to resolve it on that date. If the court needs more information about why, we're happy to approach.
Yeah, I'm going to take that up later.
Okay.
Mr. Haddad, do you have an announcement?
I do, Judge. On position number 12, Judge, it's going to be a plea. That's Jeremiah Jackson. I submitted the paperwork, the DocuSign to Mr. Randolph just a few minutes ago.
Okay.
So that's ready for a plea. On position number, Mr. Tolliver, Judge, position number 28, he did not qualify when he appeared in court on the 6th. And he had indicated that he was gonna.
Okay, and Mr. Glanville, did you say Mr. Tolliver just zoomed in?
No, that's Mr. Toller, defense attorney.
Oh, I see.
Mr. Tolliver needs to pre-trial with me.
Okay, Mr. Tolliver? Oh, he's the one in custody, right? Okay, You'll need to speak to the prosecution before you leave. Yeah, have a seat.
And Judge, I have one other announcement.
Hurry up, Mr. Lael is looking at you with daggers in his eyes.
So go
Go ahead, Mr. Haddad.
On the Orca status from this morning, Judge, number 16, Christian McKay, he thought it was 1:30 and he's here. I'm asking to reset it for a final plea. This is position number 16, Christian McKay. This is Frank Gaither's case, Judge.
Where is Mr. McKay? I want you to stay here and have Mr. Haddad confer with counsel to see if the case can get resolved today before I consider a reset.
Well, if I may, Judge, the case is not going to be it's not going to be resolved because the alleged victim apparently is deceased, and I just needed to get confirmation of that to see if the state. I'm not.
Yeah, that's what you're going to talk about. Ask them if they have confirmation and so forth. Do not leave, Mr. McKay. All right, anything else, Mr. Haddad?
No, Judge.
Okay, just remind me that he's here because right now he's got a bench warrant. All right. Let's see. How do you pronounce your last name?
Interval. Interval.
Interval. Okay.
We don't have any documents.
No, and I mean, it just sounded.
All right, this is State versus Diana Interval, middle initial O, case 21 CR 39078. This Interval was accused of DUI under the influence of alcohol, less safe, and failure to maintain lane from July 10th, 2019. Ms. Interval, you've been advised of your right to remain silent, and your counsel, Mr. Lael, will be representing you. May I place you under oath for purposes of the plea?
Yes.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, 22, Ms. Allen, what are the terms for Ms. Interval?
Thank you, Your Honor. Ms. Nitful is going to have a DUI, less safe, reduced to reckless, and pay a $400 fine. We are null crossing the failure to maintain lane. She's to complete risk reduction, an alcohol and drug evaluation, and follow through with any treatment requirements, and one victim impact panel. And once she completes those requirements, the probation will terminate. She lives out of state now.
Okay. So it's reckless driving,
yes,
12 months, credit for time served 1 day, and probation to complete these conditions?
Pay the $400 fine, and she has to complete these conditions, and probation will terminate upon completion.
Mr. Lamb, have these conditions been done?
They have, Judge, and I
Go ahead.
stay. We have them. I have them here if you'd like to see. I have all three.
Okay, the risk reduction,
Yes, ma'am.
the alcohol and drug evaluation,
Right here.
and one victim impact panel.
Yeah.
All right, upon presentation to the state, the court will deem those as completed.
I've seen and approved. Thank you.
Okay. So the only thing left is to pay the $400 fine before November 9th, 2023. Otherwise, this will be reported to the DDS for license suspension.
Yes, ma'am. She's prepared to pay today, but I know it takes a while to get in the system, but she's ready to pay today.
Isn't that sad? It takes a while to get in the system. Okay.
She'll get on Monday, Judge.
All right. Okay. And do you stipulate to the factual basis, venue, and ID, Mr. Lamb?
So stipulate, Judge.
All right. Ms. Natiful, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney services?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
If you decide to plead guilty to reckless driving, it will add points to your driver's history. You also would have to give up your constitutional right to a trial, to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of reckless driving?
Guilty, Your Honor.
Right, your sentence is going to be 12 months to serve 1 day, credit for time served 1 day, balance suspended upon payment of the $400 fine by November 9th, 2023. All right. You've completed all the conditions that were required by the state, so the only thing left is your fine. All right.
Just take one.
And I don't think there's anything left. You can pick up a copy of the disposition today or when you come down to pay the fine.
Yes. Can she pay that fine online, Judge, or does she need to come down and pay in person?
You can try to pay it online at fultonstate.org, but it's normally under the citation numbers, and this is an accused case.
Okay,
So she probably have to come downtown.
okay. We'll figure it out, Judge.
Okay,
Okay. That's all I have today, Judge. Thank you.
thank you, Mr. Leo.
Okay. Go this way.
Mr. Leo?
Oh, yeah, that's fine.
All right, this is the plea sheet for Mr. Tiffel. This is the non-cross for Jean Baptiste. Okay. Counsel, your client's name is?
Manuel Rivera, Judge, I think we were next. We submitted on DocuSign, early this morning. Manuel Rivera.
No, hang on. This one's still on hold. No, I don't have it, sir.
You don't have the DocuSign?
No, I don't.
I've got a printout of it and it shows that it was accepted, Judge. I could provide it to the court. I got an email saying it had been accepted.
Okay.
Email it to. Forward the email to you.
All right, as soon as we get the printout or,
I have the printout here and I'll forward.
okay, if you'd like to give that to us, we can make a copy and use that instead. Is Miss Luss still talking to her attorney, client?
Yes, I'm here. Yes, Mr. Dickerson was able to clarify things with his.
Okay, as soon as I'm done with this one, I'll take you all up next.
Thank you.
Oh, yes, Miss Watson Cafe. Yeah, what was your client's name? Repeat the last name? Salter. Okay, yes. Okay, Neil Salter has not appeared for the final plea calendar. What's the state's announcement?
We'd be requesting a bench warrant, Your Honor. arrest
Any
warrant.
comments, Watson Cafe? Understood. All right, bond is set at $1,000 surety. It's a bench warrant. Please, if you reach your client, let them know that they need to file the appropriate motion to set aside. All right, thank you. Yes, thank you, Ms. Watson Cafe. All right, thank you. Counsel, if you want to,
Yep,
Mr. Rivera
absolutely.
wants to come
I
there.
appreciate that courtesy, Judge. Thank you.
No, thank you. I'm glad you have the paperwork right in your hands. This is State versus Miss Manuela Rivera, 21 CR 15598. Ms. Rivera had been accused of DUI, driving under the influence of alcohol less safe, failure to report striking a fixed object, and improper erratic lane change on March 29th, 2021. Ms. Rivera is present with her counsel, Mr. Sean McKilney. You have so many vowels in your name.
Yeah, that's
I
right.
apologize, sir. Okay, McKilney, is that correct?
That's correct, Judge.
Okay. All right, and Ms. Rivera, you've been advised of your right to remain silent, and so may I place you on the oath for purposes of the plea?
Yes, ma'am.
You solemnly swear and affirm the testimony you provide will be the truth, to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Allen, what are the terms for Ms. Rivera?
The offer in this case, Your Honor, is a reduction of the DUI less safe to reckless driving. And a $250 fine will be null processing the failure to report striking an object.
And the improper erratic lane
That one as
change?
well, 2 and 3.
Oh, okay.
Thank you.
I'm sorry.
And no, it's a no probationary period.
Okay. And Mr. McKelney, do you stipulate to the factual basis, venue, and ID?
We do, Judge, we stipulate.
All right. Ms. Rivera, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood what's going on?
Yes.
Are you satisfied with the legal services you received?
Yes.
And is anyone forcing you or inducing you to take this plea?
No.
And you understand that by pleading guilty to reckless driving, it will add points to your driver's history, and that you also have to give up your constitutional right to challenge this charge in a court of law, that you won't have the opportunity to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charge against you beyond a reasonable doubt.
Yes, ma'am.
Are you willing to give up these rights?
Yes.
How do you plead to one count of reckless driving?
Guilty.
Your fine is $250 payable before November 10th, 2023. So by November 9th, it has to be paid. Otherwise, the matter gets reported to the Department of Public Safety or Driver Services, and they will suspend your fine for failure to pay, your license for failure to pay.
Yes.
Anything else, sir?
Nothing. Judge, I have a hearing next week. I wanted to see if I could get the Zoom link. It's going to be in G 33. I just got retained on a case. Is there a Zoom link?
Is it a CIT case or a CR case? Orca case?
I think it's a CIT case, Judge.
All right,
There's a virtual link
Please
available.
get in touch with Patricia Lewis.
Okay. Patricia Lewis.
Yeah.
And how do I get in touch with her, Judge?
Patricia.lewis@fultoncountyga.gov.
Okay, cool. I'll do it.
All right. LEWIS.
And Patricia just the normal way.
Correct.
All right. Thanks, Judge.
All right.
Any excuse?
Yes,
I'll have
sir.
her pay it in person next week.
Okay.
Thanks.
Jennifer Hill is the other one.
Thank you, Judge.
Okay. Okay. Miss Luss?
I appreciate the court's patience with us.
No problem. Okay, Mr. Young, is he back? All right, he needs to unmute.
I am back, Your Honor.
Okay, thank you.
You're welcome.
So, I understand where we left off was, the state's, narrative of the plea offer. Mr. Young has been advised of his rights and he's been placed under oath. So, Ms. Allen, if you'd be so kind again to, articulate the state's offer.
Yes, Your Honor. So, DUI, first DUI, the sentence is statutory, and so that tends to be our offer because it's a statutory minimum. DUI less safe in this case, the offer is 12 months to serve, 24 hours. Credit for time served for 24 hours, balance probated, a $300 fine, 40 hours of community service, an alcohol drug evaluation and follow through with any treatments recommended, risk reduction class or panel, and 1 VIP, that's a victim impact panel. The remaining offenses will be dismissed.
All right. Ms. Luss, are those the terms to which your client has agreed?
That is my understanding, Your Honor.
And I understand, are we still maintaining with telephonic reporting?
Yes, Your Honor, if that is still permissible.
Yes.
Great.
Well, I don't know too many people who can tear themselves away from New Jersey, but I'll allow Mr. Young to do telephonic reporting. And do you stipulate to the factual basis, venue, and ID for the DUI charge?
We so stipulate.
All right. Mr. Young, to repeat again, have you consumed any medication or alcohol recently?
No, Your Honor.
Repeat?
No, Your Honor.
Okay, and have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with your legal services?
I am, Your Honor. Yes.
And is anyone forcing you or inducing you to take this plea offer today instead of going to trial?
No, Your Honor.
If you decide to accept this plea offer, this will be a first-time guilty plea to a DUI conviction on your record. And you'll also have to give up your constitutional right to a trial in a court of law. You will not be able to confront your accuser. You will not be able to challenge the evidence and the testimony from other witnesses brought before you. Excuse me. You will not be able to have the assistance of counsel to present any defenses or mitigating factors, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to one count of DUI less safe?
I'm guilty. I'm sorry. Guilty. Sorry.
How do you plead to one count of DUI less safe?
Guilty.
Your sentence is 12 months to serve 1 day, credit for time served 1 day. The balance of the time you'll be on probation. I'm going to permit telephonic reporting because you're geographically very far away from us. While on probation, you will pay a $300 fine plus court costs and surcharges. You will complete 40 hours of voluntary community service at any nonprofit agency that is not a church and not a school. The nonprofit agency must be classified as what we call a 501c company, and it's a tax code designation. You can verify with the agency before you engage in any community service. The agency must provide a letter signed by the supervisor with the company's letterhead indicating that you've completed at least 40 hours of voluntary community service. You must also go to a qualified healthcare provider to submit yourself to an alcohol and drug evaluation and submit to any treatment that's required at your expense. Complete a qualified risk reduction program and attend one victim impact panel. If you have any questions about the program you have to complete or the qualifications of the agency or the provider, you must consult with your probation officer before you engage with any of these conditions, just to make sure you don't waste your time and money. Do you understand?
I do. And I'm similar to, I guess there was another person that was out of state earlier. Once I finish the requirements, does the probation now go away? Is it finished at that point?
No, it doesn't go away. While you are completing these conditions and that you are reporting to probation even telephonically, you are required to pay probation fees. Once you completed the fine, the 40 hours of community service, the alcohol and drug evaluation, the risk reduction, and the victim impact panel, and you are current with your probation fees, then your probation will be non-reporting. You're still technically on probation, but you'll be non-reporting. In other words, then your probation fees do not need to be paid and you do not have to continue with the phone calls. But this is only after you are current with all your conditions.
Understood.
Anything else?
No, Your Honor, we just ask that the court accept this plea.
So accept it, and that's it. Thank you, Mr. Young. You will get an email from your attorney to fill out the probation information. You cannot leave the Zoom until that
I did
probation.
it. I'm sorry, Your Honor. I did it already in between.
Oh, do we have it?
I already sent it to him, so to the attorney's office. Do you?
Send it to Mr. Randall, please.
Okay.
Because he's going to make sure that the case, that the information is sent to probation. All right, thank you.
Great.
And Mr. Young, the phone number of the probation office is listed on the probation form that you filled out.
Okay, great. Am I allowed to leave now?
Yep, you are now. Thank you.
Thank you. Have a good week.
You too.
Can you grab one from probation?
Miss Rainwater, are we ready to is there a reason why we have, Ms. Sheriff still on Zoom?
Yes, Your Honor, Ms. Sheriff's screen froze during the plea and you had, I think you had just said, let's wait a minute until she rejoins. And so she is
All
here
right.
and we are ready to go forward.
Okay, thank you. Mr. Arrington, has your client filled out the form and sent it to?
Yes, yeah.
Mr. Randall, do you have the form for, oh, I think I do. Terrell Williams? Is that your client?
It is, Your Honor.
All right. I don't know where I put Miss Sheriff's form.
I printed out.
It's representing Jeremiah Montrell Jackson.
I am, Judge.
All right, that would be next, okay?
And I'll handle that plea for Mr. Haddad.
All right, and then after that, I'll have Angelina Nava. I think Miss Helen is representing her.
That's correct, Judge.
All right, and then after that, I have Miss Helen for Samia Langston.
Awesome. Thank you, Judge.
Okay. I just also need to finish Miss Sheriff's. Mr. Randall, could you reprint Miss Sheriff, please, Raven Sheriff? I think I sent it back to you. Okay. This is state versus, is it Terrell or Terrell?
Terrell.
Terrell Williams, 19 CR 010342G. Mr. Williams was accused of DUI, driving under the influence of alcohol less safe, reckless driving, failure to maintain lane or improper lane change, and operating a vehicle knowingly with a suspended or canceled registration. Mr. Williams, you've been advised of your right to remain silent, and your attorney is Mr. Marvin Arrington Jr. And may I place you under oath for purposes of the plea?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Allen, what are the terms for Mr. Williams?
Well, we've gone back and forth a little bit today, and I reviewed the file and spoke to Mr. Arrington, and I think what his client is interested in doing is submitting a guilty plea to the reckless driving instead of DUI. So we would reduce DUI to reckless driving and null pros the remaining counts 2, 3, and 4. Or no, excuse me, reckless driving, and we would keep the failure to maintain a lane. We'd be pleading to 2 counts instead of just the DUI, but the DUI would be reduced to reckless driving. And he'd have a 24-month period of probation.
Okay.
So we need to redo the documents because 2 versions were submitted. We can do that.
So are you going to resubmit the document?
Is that what you would like?
Well, yeah, because.
Is it confusing? Yes.
Well, everything I've got is just pleading to 1 count or DUI less safe. And then you are going to null pros, reckless, and
correct. So
the other charges.
I'll resubmit them. Do you want them on paper or digitally?
On paper, whatever. Oh, I can, if there's any objection, I'm just going to write it on this.
I can do it here.
Sheet.
Thank you.
That's fine, Your Honor. We just, the reckless is, I guess, the final agreement that we reached, and,
because this is the agreement first signed by you for DUI less safe.
okay, I think that that's the one that was sent, I guess, digitally, so I wasn't able to see it properly on my phone, but I think so I guess we need to cross that paperwork out. We can just start over.
All right, so if you don't mind, because what I have was DUI less safe, signed off by everyone. So if y'all have revisited the agreement, I need a revised agreement.
Yes, ma'am.
All right, thank you. Okay. Miss Rainwater, give me a moment. I think I misplaced Miss Cher's plea paperwork.
Okay.
So if you don't mind, I just need to get it reprinted.
Yes, Your Honor.
Okay, thank you. Mr. Mr. Haddad for Jeremiah Montrell Jackson. And while I'm waiting for Mr. Jackson to get to the podium, Miss Helen, what was the thing with Michael Petway?
And for Judge, we were trying to because Mr. Petway does not have a scanner. So I have just gone through Google how to scan with an iPhone. I've tried to send those images to Miss Allen. The first image was proof of incarceration for Smyrna. The second images were proof of medical services received early November for his medical condition. And I just wanted to see if Miss Allen got those. He does have the documents, Judge, but he's just using an iPhone capability to scan it. I have no problem getting these documents from Mr. Petway so that maybe I could scan them. But if we could get a reset, Judge, I'd be able to provide state with better copies.
And then also, I think you said you sent them to Miss Allen, but you could send them to me.
I apologize. Let's forward that.
What positions were these? Michael.
And he's on the show cause calendar positions
Show
2 and
cause
3.
calendar. Okay, I'm sorry.
I also tried to send a copy to Mr. Randolph. I don't know if he got a clear copy of that.
I got a copy of the release report.
Okay.
So, but it says transferred to Fulton County, released to Fulton County something. Was it the detention facility?
Judge, I believe he went from the Rice Street precinct to Fulton County, but that in that transition, he had already missed the Fulton County court date. I apologize, I'm missing something.
He was released from Rice Street. That would have been Fulton County. So
not Rice Street, Judge. Mr. Petway, come back on, turn your video on for us. So we're trying to gauge the timeline, Mr. Petway. You were at Smyrna precinct?
I was incarcerated in the city of Smyrna at the beginning of May, and I received notice in the mail of I think it was a July 7th court date for Fulton County, but I was in the Smyrna jail, and although I was able to get the information for the Zoom hearing, the jail would not allow me unless the court contacted the jail and requested me. So then when I was released from the city of Smyrna, I was taken to Rice Street because I had a failure to appear, in which I then bonded out on the failure to appear. I paid the bond.
okay. Ms. Githia, do you have all this paperwork?
I do, Your Honor. I'm just wondering, do we need the Smyrna dates also, because that will coincide with
the Smyrna date I have is on a release report, is a copy of a email that was sent to Miss Allen. I'm assuming that that was been forwarded to you as well.
And I have it, Your Honor.
Yeah, and it confirms that he was booked in at May 11th, 2023 at 1800 hours and released on August 10th, 2023 to Fulton County Jail.
Okay, as long as you
do you have any objection to having these cases reset for, I'm sorry, Miss Helen, reset for motions, did you say?
Yes, Judge, we'd like a motions calendar for both cases.
Okay. Any objection, Ms. Githia?
No objection.
Reset our motions calendar, that's January 19th.
At 9 a.m.?
At 9 a.m. And he would need to be here in person.
That's correct, Judge. Motions are in person. I will be there as well.
Mr. Petway, do you understand, sir?
Yes, yes, Judge. Yes, Your Honor. Thank you. Thank you so much for helping and working with me.
All right. See you on January 19th. Thank you.
Yes, ma'am.
Thank you, Judge.
Thank you, Judge.
Okay. Sorry, Mr. Haddad.
No, you're fine, Judge.
Okay, this is Mr. Jackson. Jeremiah Montrell Jackson's case is 22 CR 7195, in which he was accused of driving in circular or zigzag course, otherwise known as laying drag, and reckless driving. This is from a June 14, 2020 incident. And Mr. Jackson, you've been advised of your right to remain silent. Your counsel is Mr. Juan Haddad. Mr. Jackson, for purposes of this plea, may I place you under oath?
Yes.
Do you solemnly, at the right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Githia, what's the plea offer for Mr. Jackson?
For the driving in circular or zigzag course, laying drags is 12 months probation, a $700 fine. Stay away from Tony's Sports Bar located at 10305 Medlock Bridge Road in Johns Creek. And for the reckless driving, it merges into count one.
All right.
Does the defense stipulate to the facts, venue, and ID?
We do, Judge.
Mr. Jackson, have you consumed any medication or alcohol recently?
No.
And have you understood what's going on?
Yes.
And are you satisfied with your legal services?
Yes.
Is anyone forcing you or inducing you to take this plea offer today?
No.
And you understand that if you plead guilty to this charge, it will add points to your driver's history. And also you would have to give up your constitutional right to a trial. You will not have the assistance of counsel to be able to confront your accuser, challenge the evidence brought against you, have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of laying drag or driving zigzag? So,
Guilty.
I always have a comical thing in my head when I
Right.
hear zigzag. Okay. I'll accept your guilty plea. Your sentence is 12 months probation.
And I apologize, Judge. I did want to clear up. My client's first name is misspelled and we waive any issues. His real name is the normal spelling of Jeremiah. I just want to let the court know.
Is that Jeremiah?
Yes.
Okay, so it's missing an E.
That's correct, Judge. And
Okay.
and I apologize for interrupting.
No problem.
I would request the court to consider waiving the first 3 months of his probation fees in light of the fine. He's got a couple of young children, Judge, that he supports. So I would ask the court, and one thing I completely forgot to mention to request either Ms. Githia or the court is the consider possibility of either terminating or placing his probation non-reporting. Actually, non-reporting because there's a special condition of a stay away from the bar, but I would ask non-reporting probation once he pays the fines and everything, Judge.
Any objection to non-reporting, Ms. Githia?
Give me just 1 second.
And I apologize, Judge. I inherited this case now, and I was emailing with the solicitor back and forth, and I completely forgot to ask her about the non-reporting, Judge.
No problem. You're becoming a pro at inheriting cases.
No objection.
All right.
Just the drags, it's a lot less.
All right. So on the 12 months probation, I will waive the probation fees for the months of November, December, and January. He will report to probation next Thursday before 3 p.m. While he's on probation, he will pay the $700 fine plus court costs and surcharges. And at all times, he's to stay away from 10305 Medlock Bridge Road and Johns Creek, otherwise known as Tony's Sports Bar. The reckless driving charge obviously merges, so he's only going to be guilty on one count of driving circular zigzag course. As soon as he is current with his fine payments, surcharges, and probation fees, if applicable, if he takes more than 3 months, then his probation will be non-reporting.
Thank you, Judge.
And Mr. Jackson, if you return to the Tony Sports Bar while you are on active or non-reporting probation, they can have you arrested for criminal trespass.
Yes, ma'am.
All right. Anything else, sir?
No, Judge, I have the probation information.
All right, thank you.
Provided to.
Oh, Mr. Petway, you're excused. You can log off. Thank you.
Ms. Raven Sheriff, we're going to resume with your plea hearing.
Thank you, Judge. And Ms. Sheriff is here virtually still.
Okay.
And if I can just go back to Mr. Jackson really quickly. Just looking at the calendar, it's spelled JERMIAH. Is that something that the clerk needs to be made aware of, so all the changes are made?
Well, he made a note on the record that the name is misspelled, but they're waiving any objection to the deficiency or the typo. So we can keep it as Jeremiah Jackson, the way it's spelled. And he will be reporting under that case because he's waived any spelling defects.
Okay, thank you.
Mr. Randolph, I'm just going to put these, I think my taskmaster is just sending me an endless supply of paper. Okay. I am resuming the plea hearing for State versus Raven Sheriff, 21 CR 004-031F. Ms. Sheriff, you've been advised of your rights. You've been placed under oath. The state and your attorney, Ms. Rainwater, have gone over any corrections with your plea, with the terms of your plea offer. And unfortunately, we had to stop in order to correct any technical issues. So let's resume with this case. And the host can go ahead and correct the name on Ms. Sheriff's Zoom panel to Raven Sheriff, common spellings. All right, so just to clarify, Ms. Sheriff is going to, if she pleads guilty to the charge of 1 count of battery, the sentence will be 12 months to serve 5 days, credit for time served 1 day, 40 hours of community service. The jail time and the community service are going to be suspended upon proof of completing the treatment program that she's currently undergoing. She is to have no violent contact with Mallory. Spell the last name again. Bellino. Bellino.
Yes, Your Honor.
And she is to complete an alcohol and drug evaluation, and it's going to be telephonic recording. Correct?
Yes, Judge.
And do you stipulate the factual basis, venue, and ID in this case, Ms. Rainwater?
We so stipulate to factual basis, venue, and ID, Your Honor.
All right. And have you received the probation form to fill out for your client?
I have not received it, Your Honor.
All right. It will have the probation telephone number at the top where she would have to make her calls. All right?
Yes, Judge. Would I request for that from Mr. Randolph?
Yes.
Okay. Thank you, Judge.
Ms. Sheriff, you're already under oath. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea offer and give up your right to a trial?
No, ma'am.
And do you understand that if you decide to plead guilty to this charge, that you would have to give up your constitutional right to have a trial before a judge or a jury, to have the assistance of counsel to go back to court, confront your accuser, challenge the evidence and witnesses brought before you, present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead to one count of battery?
I plead guilty.
Your sentence is going to be 12 months to serve 5 days, credit for time served 1 day, and complete 40 hours of community service. The jail time and the community service are suspended upon submission of the completion of the treatment program that you're currently undergoing. The certificate of completion must be submitted to your probation officer. Ms. Rainwater, whoever is a probation officer, y'all need to be in communication so that the PO gets the certificate in order to suspend the jail time and the community service.
Understood, Judge.
Right? You would also need to submit to an independent alcohol and drug evaluation. I'm sure you could do it at the treatment facility if there's a qualified healthcare provider, and submit yourself to any treatment that's required. At all times while you're on probation, you're not to have any violent contact with Mallory Bellino. You're not to be in possession of any weapons or firearms. You're not to consume any alcohol and no illegal drugs. I'm going to permit you to do telephonic reporting. So your first report date is going to be November 9th, 2023 before 3 p.m. It's important that you call on that day before 3 p.m. and you connect with your probation officer. And the phone number and the address of the probation office will be provided to you on that probation form. You must complete that form before you leave the Zoom.
Yes, ma'am.
Okay. Anything else, Ms. Rainwater?
Nothing else, Judge. I got confirmation from English Hill that we are getting that form, so we will complete that and send it back to the court.
Okay, thank you.
Thank you, Judge.
Oliver.
I think Mr. Spisman is, okay, that was an old call. I have counsel, Mr. Henry Toll, is it?
Yes, Your Honor, that's correct.
And who is your client?
My client, Joseph Lanier.
And where is Mr. Lanier?
He's picking his children up, but as soon as he gets back to his house, he can log on.
Okay, is Mr. Lanier back on? Not yet. Okay.
Not yet, but, I mean, he's been available all day. We weren't sure if it's a morning or afternoon calendar. We got the link late, but I could have him log on if you need. We're gonna ask.
Okay. As soon as he logs on, I'll address your case. Okay.
We just want to go to a jury counter, Your Honor.
Y'all don't have a.
Is this final plea? I'm not sure. I didn't get a notice. Is this final plea?
This is final plea, and I've got a note here that he applied for DUI court, so I need him to appear to inquire about that.
He's still undecided about that. I don't think, Your Honor, he's principal owner of a startup international wholesale food company, and he travels all the time, and it doesn't seem like it's a good fit because of his travel.
I'm so sorry, but he's charged with DUI. He needs to show up in court. And coming via Zoom is not the way to do it, because folks are supposed to show up actually in person unless they get permission from the court to appear via Zoom. So where is he?
I have him up here in a few minutes, but we never got a notice for this, either one of us, but I got an email yesterday from the prosecutors while we knew about appearing today, and I just got the link about an hour and a half ago or 2 hours ago, and that's when we signed. But I'll have him appear though.
Okay.
Oops.
Sounds good. Thank you.
Thank you.
Angelina Nava. All right.
Ms. Nava's position number 21, and that's 3 felons.
And this is Miss Helen's case, right? Miss Helen? Right. Mr. Haddad or Ms. Rosenhuber, do y'all have a plea ready?
Yes, Judge.
Which one do you have?
I have position number 3, Miss Cobb. She is out in the hallway with her newborn, but she's ready to come in and
Okay, let's do that one because she's done that. Her child. Ms. Nala, have a seat back there as soon as your attorney is available.
Probation and a $250 fine, and I'll suspend the probation once you pay this, and we can't have any further violent contact.
And Judge, I apologize if I'm interrupting. I couldn't remember if we already took Miss Nava and Miss Langston's pleas, or we're still.
No, I've never taken them. So I'm going to address Ms. Cobb first, and then I'll go back
Understood.
to your client, okay?
Thank you so much, Judge.
Hindering the phone call.
All squared away? Mr. Arrington?
Yes, we are.
Okay.
You'll pay $250, be on probation. Yeah. We can offer and let the judge know.
All right. This is State versus Centricia Amia Cobb, 21 CR 7671D. Formerly accused of simple battery and disorderly conduct. I'm not formally, but currently accused of simple battery and disorderly conduct from March 27, 2021. Ms. Cobb, you've been advised of your right to remain silent, and your attorney is going to be Ms. Rosenhuber. Well, figuratively, you got your right hand up. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. All right. Miss Allen, what is the plea terms for Ms. Cobb?
That I would be handling that one.
I'm
Your
sorry,
Honor.
Ms. Githia, sorry. Go ahead.
For the simple battery and disorderly conduct, it is 12 months probation, 6 anger management classes as approved by probation, no contact with the victims, Sal Matu Bangura and Batu Mata Foinke, to stay away from 2769 Donald Lee Hollowell Parkway Northwest, located in Atlanta, and probation may terminate upon completion of the conditions. Does the defense stipulate to the facts, venue, and ID?
yes, we do.
All right. And Ms. Cobb, have you consumed any medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
And are you satisfied with your attorney services?
Yes.
And is anyone forcing you or inducing you to take this plea offer and give
No.
the right to a trial?
No.
You do understand that you do have a right to a trial, to confront your accuser, to challenge the witnesses, and this okay, to challenge the evidence and the witnesses brought before you.
Yes.
Present any mitigating factors or defenses if you choose to do so,
Yes.
and to have the state try to prove the charges against you beyond a reasonable doubt.
Yes.
Are you prepared to give up these rights?
Yes.
How do you plead to one count of simple battery and disorderly conduct?
Yes.
How do you plead?
Oh, guilty.
Your sentence for both counts is going to be concurrent. It's 12 months to be served on probation. You will report to the probation office next Thursday at 132 Mitchell Street in downtown Atlanta.
Okay.
That's going to be next Thursday before 3 p.m.
Okay.
All right. Before you leave, you'll need to fill out the probation form, and you will get that probation form. The address and everything's up there. But
Okay.
don't forget. Okay, she's got it.
I'll already have that, yes.
Okay. While on probation, you will complete 6 anger management classes and have no contact with Miss Bangura and Miss Foinke.
Okay.
That's the best I can do with the pronunciations. You're also to stay away from 2769 Donald Lee Hollowell Parkway in Atlanta, Georgia. Once you've completed the anger management classes and are current with your probation fees, your probation will terminate.
Okay.
All right. As soon as you fill out the form, you are free to go.
It's all filled up. I'll walk away so you can get yours.
Mr. Arrington, are you ready?
We are, Your Honor. We're
Did-
going with
do we-
the original paperwork that you had.
Good thing I didn't tear it up. Okay, there we go. Okay. All right, we're going to resume the plea hearing with State versus Terrell Williams, 19 CR 10342G. Mr. Williams has already been sworn, and the state's and he's been advised of his rights. And the state's offer, just for the record, is
So, Mr. Williams was given the option of, taking a reduction to reckless driving instead of the DUI. He is choosing to go ahead and plead guilty to the DUI. So count one, DUI is, 12 months to serve 24 hours, credit for time served for 24 hours, balance probated, a $300 fine, 40 hours of community service, risk reduction panel, an alcohol drug evaluation and treatment if recommended, and one victim impact panel. And that is going to include a 1-year suspension. This is a 12-month period of probation complete, and not 24 as the other offer contemplated, and will be null processing counts 2, 3, and 4.
right. Mr. Arrington, does your client stipulate to the factual basis, venue, and ID?
He does, Your Honor.
Right. And Mr. Williams, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes.
And is anyone forcing you, inducing you to take this plea offer today?
No, Your Honor.
Are you satisfied with your attorney services?
Yes, ma'am.
And has it been explained to you that if you decide to plead guilty, you will be giving up your right to a trial before a judge or a jury?
Yes.
You will give up your right to have the assistance of counsel to challenge the evidence and the witnesses brought before you, confront your accuser, have the state present and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You also will give up your right to file an appeal.
Yes.
But my sentence will be conclusive. That will be the end of the case.
Oh, yes, ma'am.
All right. And how do you plead to one count of DUI less safe?
Guilty.
This will be, I believe, a first in a lifetime conviction for DUI?
Yes, Your Honor. We would ask for the certificate of first conviction.
Okay. He would need to surrender his driver's license today. Is he prepared to do that?
I don't know if he has it, Your Honor.
Okay, he would need to come down and surrender that driver's license.
Okay.
Otherwise, from this point onwards, his license will be deemed suspended.
Yes, ma'am. Yes, Your Honor.
So just to say, he's pleading guilty to DUI less safe. The sentence is 12 months to serve 1 day, credit for time served 1 day. You will be on probation. Your first report date is November 9th before 3 p.m. at 132 Mitchell Street in downtown Atlanta.
ma'am.
While on probation, you will pay a $300 fine plus court costs and surcharges. Complete 40 hours of community service at any nonprofit agency, which is not a church and not a school. You will also complete a risk reduction program, an alcohol and drug evaluation, and submit yourself to any treatment that's required. Attend a victim impact panel, at least one of them, with your probation office. Your license will be suspended for 1 year. I will grant an affidavit of first conviction, which means that upon your surrender of your driver's license, we can give you that affidavit, which you would take to the Department of Public Safety, and you will be provided a limited driving permit.
Yes.
You can use that limited driving permit for only necessary travel, like work, medical, going to school, going to church, groceries, stuff like that, but not for recreational or leisure purposes. Okay? That's the sentence. Anything else, sir?
No, that's all that we have, Your Honor. Would ask if the probation can terminate or suspend once he completes the other requirements.
Not for DUI, sir.
Okay.
Right? Thank you.
Thank you, Your Honor. That's all I have. May we be excused?
Yes, sir. Well,
And
he
we
needs to
need
fill out the
prove
probation.
license too. Okay.
All right. Driver's license at J150, where they'll give him the affidavit of first, well, once we get the license, they will send me the affidavit, which needs to be signed. And then he can pick it up from the clerk's office when it's ready.
Thank you, Your Honor.
All right.
Thank you.
He needs to fill out that probation form. Has he done so, sir?
No, I think we're gonna give her probation.
Okay.
No, I just have to approach to address Samuel Johnson.
And Your Honor, may we be excused once we've completed the probation paperwork?
Definitely, yes. Thank you.
Judge.
They're gonna ask for a final plea unless they're ready to talk across the case.
Which one? Have you found it? You're gonna ask for a reset so we can look at it. That's fine. That's fine. Thanks.
Miss Helen, are you ready? Are you on mute?
Yeah. I just sent you.
All right. While we're waiting for Miss, okay, Mr. Lanier is present and Mr. Paul, okay. Is that your case, Miss Allen, or?
Your Honor.
Okay, so position 18, Joseph Robert Lanier is present. And, where's your attorney? Mr. Toller, Henry Toller. Mr. Lanier, can you send a message to your attorney to appear?
Yes, ma'am. 1 second.
Caprice Helen?
Mr. Randolph, can we have a copy of the plea colloquy so he can read it instead of on his phone?
Miss Helen?
Yes, Judge.
Okay. Angelina Neva
Call her.
is
I just sent him
in the
the document.
courtroom. This is case 21 CR 0052222F. Miss Neva was charged with simple battery, family violence, and criminal trespass from October 2nd, 2021. Miss Neva, your attorney, Miss Catrice Helen, is on Zoom. Do you see her?
Yes, I do.
Okay. You've already been advised of your right to remain silent, and your attorney, as I've said, is Miss Helen. May I place you on oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Miss Allen, what are the terms for Miss Neva? Is it Neva or Nava?
Nava.
Nava. Okay.
So Ms. Nava is going to be taking this under first offender. I don't believe I marked that or wrote
Okay.
that on the paperwork, so I want to make sure it's on there.
All right.
This is one count of simple battery, family violence, concurrent, 12 months, probation, serve 4 days and credit 4 days, balance probated, complete family violence intervention programming, and no further violent contact with the victim.
Edwin Guzman Rivera?
You got it.
Okay. Miss Helen, does your client accept these terms, and do you stipulate the factual basis, venue, and ID?
Judge, we do so stipulate, and we do ask this court to accept the plea as negotiated. It is a time served probation deal, and I have spoken to Ms. Nava about it. I also afterwards, I think for each of my cases, should I send a separate sheet for probation?
Yeah.
Okay, I just wanted to do that for all cases today, but yes, and then I'll also send a sheet for Ms. Nava, but yes, Judge, she does accept this misdemeanor probation.
All right. And so just to correct, this is not a time served. She'll be on probation to complete FWIP. And then I can do non-reporting upon completion.
And just to explain, Ms. Nava, Judge just said that once you complete the family violence intervention program, she's willing to grant non-reporting, which is call-in or phone-in probation?
No. So just to clarify what your attorney just said. If you accept this plea offer, you will have to report to probation. And you report to probation every month while you complete the 24-week program the domestic violence program. That's for 24 weeks. That's about 6 months. Once you've completed all the classes and you get the certificate, then you give your certificate to the probation officer. Then you don't have to report to probation anymore. You don't have to call in, you don't have to go into the office, but you are technically still on probation.
Okay.
That's what non-reporting means.
Okay.
So while you're doing the classes, it's reporting. Once you're done, it's non-reporting.
Okay.
That's the state's offer, and the court is allowing non-reporting. Ms. Helen, did you want to clarify anything I just said?
No, Judge, and thank you for that clarification.
So do you still want to move forward?
Yes, ma'am.
All right, and Ms. Helen, this is under the first offender plea, correct?
That is correct, Judge.
Okay, so under first offender means that since this is your first offense, once you've completed the sentence and you, after the 12 months, then this case will be considered basically on your record, but it can't be used against you.
Okay, ma'am.
All right?
Yes.
But if you violate any of the conditions while you're on probation, active or non-reporting, you lose the first offender status.
Okay, ma'am.
All right. I don't know where I was, but Ms. Nava, have you finished your narrative, right, Ms. Allen?
Yes, Your
Okay.
Honor.
Sorry, it's all beginning to go into one. Okay, Ms. Nava, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings as I've explained, your attorney has explained,
Yes,
and
ma'am.
everyone? Okay. And are you satisfied with your attorney services?
Yes, ma'am.
And is anyone forcing you to take this plea offer
No,
today?
ma'am.
If you decide to enter this guilty plea under the First Offender Act, you would have to give up your constitutional right to a trial. You would not be able to go back to court to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery, family violence, and one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 4 days, credit for time served 4 days. You have no more jail time, but you will be on probation. You report to the probation office next Thursday before 3 p.m. That's November 9th, 2023. The probation office is located at 132 Mitchell Street in downtown Atlanta.
Okay, ma'am.
Okay. While on probation, you would need to complete the domestic violence intervention program. As I said, that's a 6-month-long program, weekly classes, and you must begin that program within 60 days from today.
Okay, ma'am.
All right? So you will report to probation every month while those classes are ongoing. Once your classes are over, then you must produce a certificate to give to your probation officer, and then your probation will be non-reporting.
Okay, ma'am.
At all times, whether you're on active or non-reporting probation, you're not to have any violent contact with Edwin Guzman Rivera.
Okay.
On the criminal trespass, the sentence is going to be concurrent. All right?
Okay.
And this will be under the First Offender Act. Thank you.
And Ms. Nava is excused, Judge?
Yes, as soon as we get her probation information.
Okay, I'll go ahead and submit that. Just stay there for me, Ms. Nava, so I can get that scanned over.
Okay.
Yeah, and I'm back on my
Mr.
client.
Toll, yes, sir. So Mr.
How we do?
Lanier was supposed to apply for DUI court the last time the case was reset to get the status of the application. So what's happening now?
Again, he's the principal owner of a international wholesale food business, and it doesn't appear that he could pull off being in DUI court responsibilities. I don't think he could take care of all the responsibilities and continue to travel and run his business. So it looks like we're gonna have to go a different route. So this has to be put on a trial calendar, please.
Okay.
So Mr. Lanier was presented with an offer that is a DUI court track offer or a not DUI court track offer. And so
I don't know what the offer was, but they are turning down the DUI court.
I just want to be clear on the record that an offer was conveyed. Defense counsel is now saying DUI court is not something they're interested in applying for. And
That's what it appears.
there's no negotiation that's going to happen at this point, as far as I can tell.
Okay. Looks like the case was arraigned. A waiver of arraignment was filed on February 25th, 2022. Case management order will issue.
Who's going to be the trial judge? Do we know?
I'm sorry?
Do we know who the trial judge will be?
Most likely either me or Judge Eric Morrow.
Okay, thank you.
So right now, this case is going to be, like I was saying, a case management order will issue, and the case is reset for a jury trial. My November jury trial calendars are full, so it will have to be the next one. I think it might be in April.
Okay, thank you, Your Honor.
All right, thank you.
Your Honor, can we confirm where notice is being sent to for Mr. Toller and Mr. Lanier? Because I'm looking at notice in the court's calendar that was sent.
Okay, oh yeah, there was an issue with notice. So I have 12030 Stonebrook CV. I don't know what CV stands for. Cove?
Yes, ma'am.
Is that the correct address?
No, ma'am.
When did you change your address?
2 years ago and 2 months, or 2 years ago and 2.5 months.
2 years
And it's
ago.
been changed with the U.S. Postal Service.
Well, that's good, but you're supposed to change it with the clerk of court. We are not the postal service. That's why you are not getting notices. All right, so Mr. Lanier, you'll need to come down to the clerk's office in person, suite J150 at 136 Prior Street, and I want you to fill out your current address, your phone number, and your email. Either you or your attorney can do that.
Yes, ma'am.
Thank you. We'll see you for trial. And Mr. Toller, I hope I have your current address. Let's see.
Mine's been the same for 15 years, so it should be correct. 2451 Cumberland.
Parkway? Yeah, okay, good. All right, sir, we'll see you all for trial. Mr. Lanier, please update your address as instructed. Thank you.
Yes, ma'am.
Thank you, Your Honor. Have a nice day. Good to
You
see
too.
you.
You too.
Thank you.
Thank you. Samia Lucille Langston.
Yes, Judge, that's gonna be my case, and it is a plea.
Was this a Zoom or a?
Yes, Miss Langston was.
She's here.
She was in person. Samaya, excuse me. All right, Miss Samaya Lucille Langston is present in the courtroom. This is position 17, case number 21 CR 4486E. Miss Langston was accused of driving hit and run, failure of the driver to stop at or return to the scene of the accident, driving while license suspended or revoked, and following too closely from a June 28, 2021 incident. These three charges have been accused. Ms. Langston, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. Do you see her on the screen?
Yes, ma'am.
You can come closer because that microphone needs to pick up your voice. Thank you.
Yes, ma'am.
Thank you. For purposes of the plea, could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Allen or is Ms. Allen's case?
Yes.
Yeah, all right.
Your Honor, the case dealing with Miss Langston is a hit and run, driving while a license is suspended or revoked and following too closely from 2021. The offer in this case is 12 months probation for following too closely. That's count 3. I'll be null processing count 1 and 2. Credit for any time served, balance on probation. She has requested that this be first offender, and we are in agreement. And Ms. Langston has agreed to pay restitution in the amount of $1,249.21 to the victim in this case, Nicole Mosley, Nicole. Mosley is Mosley. She has already shown proof of a current license. And we are amenable to once restitution is paid, probation can terminate.
All right.
She is not currently driving, although she is a licensed driver at this point. So we're not worried about the insurance now.
Okay. Ms. Helen, are those the terms to which your client has agreed, and do you stipulate to the factual basis, venue, and ID?
We do so stipulate, Judge, and we do ask this court to accept the plea as negotiated.
1 second, please.
We can talk to the court and tell them my recommendation is that we
Just notice the recording just went off. Just give me a moment.
The live stream is still going, Your Honor, but the recording ran out, or because the computer ran out of space.
What do? We need this recorded since it's a plea offer.
The live stream is still going though, meaning
No, the live
it's
stream.
on YouTube.
The live stream maintains open court principle, but the recording is required for the plea. Do you have to start a new Zoom?
if you pull up your phone, make
Give me a second, Your Honor.
Okay.
dots on and I'll help you if that's.
John.
Sorry, Ms. Langston, please have a seat. We have to resolve this technical issue. Thank you, Mr. Glanville. All right, Ms. Langston, please. Samaya. Lucille Langston and Helen, we are back on recording. This is 21 CR 004486. Samaya Lucille Langston is accused of hit and run, following too closely and driving while license suspended. I'm sorry, Ms. Langston, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen. For purposes of the plea.
Oh,
Yes. Mr. Glanville,
why does that happen?
because it's Friday and it's time for Zoom's era, so. As I was saying, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Ms. Allen, I understand the state's going to null pros the hit and run and the driving while license suspender revoke. What's the plea offer for following too closely?
Following too closely is a 12-month probation, credit for the time served that she has already. This is agreed that the balance will be probated and actually terminate once she completes a payment of restitution. And this is under first offender. So the restitution amount is $1,249.21 payable to Nicole Mosley, Nicole. Mosley is Mosley. And Ms. Langston has already provided proof of a current driver's license. She is not currently driving her vehicle, or she doesn't have a vehicle, so we're not worried about the proof of insurance at this point. So yes, we'll be null processing counts 2 and 3, or no, counts 1 and 2, excuse me, and moving forward only on count 3 following too closely.
Okay. Ms. Helen, do you stipulate to the factual basis, venue, and ID, and does your client agree to these terms?
Yes, Judge, we do so stipulate to the factual basis, venue, and ID, and we ask this court to accept the plea as negotiated.
All right. Ms. Langston, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has anyone induced you or offered you something for this plea offer?
No, ma'am.
Do you understand that if I accept this guilty plea under the First Offender Act, that you will be giving up your right to a trial, to confront your accuser, challenge the evidence brought against you, and have the state try to prove the original charges against you beyond a reasonable doubt?
Yes, ma'am.
How do you plead to one count of following too closely?
Guilty.
I'll accept your guilty plea under the first offender. Your sentence is 12 months, credit for time served. You will begin your probation next Thursday. You'll report to probation at 132 Mitchell Street at before 3 p.m. While on probation, you will report every month until the full restitution amount of $1,249.21 is paid off to Nicole Mosley. After the probation confirms that full payment has been received, then probation will terminate. Probation is responsible for accepting the payments and remitting them to the victim. Do you have any questions about the sentence?
No, ma'am.
Right, you will need to fill out the probation form before you leave the courtroom, all right?
Yes, ma'am.
Thank you.
Thank you.
Mr. Tolliver? Done for Mr. Lemire. Sit down. Deputy Marshal, this is the case that y'all have alerted me about as well. Okay. Mr. Tolliver, I understand that you are representing yourself because your attorney, Karen Pass, has withdrawn from the case.
Yes, ma'am.
Is that correct? And have you made any attempts to retain different counsel?
I have, but they said I didn't meet the requirements, so
it's kind of pricey for me right now to find someone else outside of the public defender.
All right. In this particular case, again, I'll remind you that you have a right to remain silent about the facts of the case. You have a right to counsel. Unfortunately, you do not qualify for the services of the public defender's office. So you would have to retain your own attorney, or you can choose to represent yourself. Understanding that you are responsible for understanding the law and the procedures as it applies to the facts of your case. You're responsible for any legal decision you make as how it may impact your current situation in terms of any other open cases you may have, in terms of your residency if applicable, in terms of any license, professional licenses you may have, and or any other open probation cases you may have. You understand?
Yes, ma'am.
All right. I know that currently you have a case 19 CR 009923F. I also need to inform you that you have an outstanding warrant.
We've already cleared him for the FTA one.
So he doesn't have the warrant now?
No, he's clear.
He's clear?
Yes.
Okay, so he may be clear, move forward with this case?
Yes.
Okay, so you did have an outstanding warrant, 231868 FTA, but it appears that it's been cleared out, so you're good to go. Are you willing to enter into a plea offer with the state?
Yes, ma'am.
All right, and have you signed up on the documents?
Yes, ma'am.
All right, and have you received the signed documents, Mr. Randall?
He might need some help with his phone, the screen. You pull it up?
I sent it. It said finish. So
Let me look at my.
All right, so as soon as we print up the plea documents that you submitted, all right?
I got it.
All right, as soon as we print it up, we're gonna proceed with your plea hearing. Okay?
All right.
Please have a seat. Is probation required?
No, Your Honor.
All right, now the gentleman sitting behind you, what's your name, sir?
Linnell Green.
Who?
Linnell Green.
Mr. Green, have you spoken to the prosecutor?
I have not.
Come on, feet.
Yeah.
On this docket, what position?
Yeah, 9.
Thank you.
Yes, we spoke this afternoon, Your Honor.
Oh, you spoke with Ms. Githia?
Briefly, yes.
Okay.
And what have you all decided?
So we didn't come to a decision. So I had a lawyer up until August. I paid $6,000 for the lawyer, and he went out of business, closed his practice. And a month later, I saw the notice to come to the court for Zoom for October. I did that, and then you said I needed to appear. I tried to get a public defender, which my salary requirements did not meet. So to be honest with you, Your Honor, I'm kind of in a position where I'm out $6,000, and I'm trying to find out what's the next best thing that I can do. I've reached out to one lawyer, but to have to pay another few $1,000s for this case is not something that I can do right now. So trying to look at my options.
Well,
I was in a position to contest the charges. Obviously, when I had my lawyer, I felt pretty confident about that, but that has changed.
did your attorney send you notices that they were closing shop?
Yes, he did.
So did you go back to them and say, I need my money back to get another lawyer?
He advised me that he had a recommendation of people that could pick up my case, but that didn't solve the monetary situation. When I reached out to one of the recommendations, they said that they cannot pick up my case without.
Well, did you look at your retainer agreement to see what were the issues with the funding?
No, I did not, ma'am.
Okay, but I can't help you there, sir, because that is strictly a contractual issue between you and your former attorney. With regards to your case, and like you said, you don't qualify for the Public Defender's Office. And this case has already been arraigned and you entered a not guilty plea on September 24th, 2021. Look, I'm not sure what conversations you had with your former attorney about all the information that he obtained from the state, discovery and so forth. Your lawyer was Adam Brown, so he withdrew from the case on July 3rd, 2023. I'm assuming you hired him back at that time when you were arrested?
Yeah, right, immediately, right away, yes.
So he's been your attorney for about
2 years?
2 years. So I don't know what the retainer agreement says about the fees, but you would need to most likely hire another attorney because your case is going to be set for trial in April.
Okay.
Right? We're going to issue a case management order. The case is going to be set for a jury trial. You need to retain counsel as soon as possible to get ready for trial and make sure that your new attorney gets all the discovery information. Best thing to do is go back to Mr. Brown and see if he can give you your entire case file that he has, because he's required to retain his records for so many years, even though he's closed shop.
Okay, thank you for that information.
All right, so we will send you notice of your trial date. Like I said, time is of the essence. I have a Northwoods Lake Court address. Is that correct?
Yes, ma'am.
All right. That concludes your case. You're free to go.
All right, thank you.
Thank you.
Thank you.
Oh, hang on. Before you leave, we're going to give you the case management order to give it to your new attorney.
Okay.
Yeah, he grabs you.
Okay.
Thank you. Mr. Randolph, do we have Mr. Tolliver? Oh, here, just sorry.
Yes.
Okay. All right, Mr. Tolliver.
Okay, wait.
This is State versus Andrew Tolliver, case number 19.
No, we're okay, we're okay. It's just not gonna show there anymore because it's logged out 4:30.
Yeah.
But we're still on the computers.
We're still being recorded. Okay. This is State versus Andrew Tolliver, case number 19 CR 9923F. Mr. Tolliver is charged with hindering a person from making an emergency phone call, theft by taking, battery, family violence, and cruelty in the third degree. With regards to these 4 charges stemming from a September 14, 2019 incident in Fulton County, Georgia, the Mr. Tolliver is presently in court in person, appearing self-represented. His former counsel, Karen Pass, had withdrawn from the case. Mr. Tolliver has been advised of his right to counsel and or to the consequences of representing himself. Mr. Tolliver, I need you to read the first paragraph on the document I'm going to show you. And if you agree to those terms, you need to sign and date by the X's. And I'm handing him the waiver of counsel form.
Thank you, Your Honor.
Mr. Tolliver, you've signed off on the waiver of right of counsel. Did you understand the paragraph you read?
Yes, ma'am.
And you are willingly, knowingly, and voluntarily waiving the right to counsel?
Yes, ma'am.
All right, sir. Please raise your right hand. Do you solemnly swear to affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Right? We're first going to hear from the prosecution as to what the terms of the offer are, and then I will ask you some questions. Ms. Allen?
Thank you, Your Honor. So Mr. Tolliver was originally charged with 3 charges in this case. One, hindering an emergency telephone call. Yes?
4 charges.
Okay, thank you. Yes. Hindering an emergency call, number 1. Number 2, theft by taking misdemeanor. Number 3, battery, family violence. And number 4, cruelty to children in the 3rd degree. This is an incident from 2019. And as you said earlier, his attorney withdrew in August of this year. Our office has been in contact with the victim in this case. Our offer today to Mr. Tolliver as a pro se defendant was to plead guilty to the battery, family violence, which is position number 3. Counts 1, 2, and 4 will be null prost. It's a 12-month period of probation. He's to pay a $250 fine, and once he pays that fine, his probationary period can be suspended.
Right, Mr. Tolliver, have you consumed any medication or alcohol recently?
No, ma'am.
All right. And do you understand that for me to move forward with this plea hearing, you need to agree that the factual basis that the state's relying upon to make this offer is true and correct? Do you agree?
Yes, ma'am.
Do you agree that the named defendant, Andrew Cornelius Tolliver, is you?
Yes, ma'am.
And do you agree that this incident occurred in Fulton County, Georgia?
Yes, ma'am.
Right? And is anyone forcing you or inducing you to take this plea offer today?
No, ma'am.
And are you doing so freely, willingly, and knowingly?
Yes, ma'am.
Do you understand that if you plead guilty to battery, family violence, and it goes on your record, any subsequent arrest for a similar offense will automatically be a felony charge?
Yes, ma'am.
Right? And also, when you read through the documents, do you understand that you will be having to give up your rights to a trial in front of a judge or a jury to be able to go back to court, confront your accuser, challenge the evidence and the witnesses brought against you, to have the opportunity to present any mitigating factors or any defenses if you choose to do so, and also to have the state try to prove the original charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
Right? How do you plead to one count of battery, family violence?
Yes.
Your sentence is 12 months probation. Your first report date is going to be November 9th, 2023, before 3 p.m. The probation office is at 132 Mitchell Street in downtown Atlanta. You must report on that date before 3 p.m. While you're on probation, you are to complete, you have to pay a $250 fine, and you are to have no violent contact with John Francois Minette. Is that your understanding?
Yes, ma'am.
Right. Which means you can have contact with John Francois, but it cannot be physical. It cannot be an altercation which is physical or verbal.
Understand.
Okay. Now, if you pay off the fine, the remainder time for probation is terminated.
Okay, understood.
Understood?
Yes, ma'am.
All right. And the other remaining counts are going to be dismissed.
All right, thank you.
All right. Please stay in the courtroom until you fill out the probation form, unless you've done so. And then you are free to go with a report date for next Thursday. Thank you. Ma'am, is she?
She would have.
Okay, yeah. All right, go ahead.
Says, okay, oh wait, what's his other condition?
He's on probation to make sure to pay off that fine. But if he pays it before next Thursday, then he doesn't have to report.
So when we do the QR, I will report it out probation. What is the number of choice?
Well, Miss Allen, based.
Mr. Tolliver?
Yeah, what is being.
His only condition is to not have any further violent contact.
Yeah, so let's do non-reporting probation then, because you have a.
Suspended,
condition.
am I not saying the right word?
Yeah, balance suspended means that he doesn't have to report, the remainder of the sentence is completed.
So ultimately, if there's any violence specifically or violations of crimes in general, we can look at that and file a revocation, but.
If you're seeking a revocation, then it's non-reporting probation. But if you are doing balance suspended, his probation ends and there's no revocation issue.
Okay.
So I need the plea paperwork back.
That's fine.
Mr. Tolliver, I understand it's fine with the state. I need to make sure it's fine with Mr. Tolliver.
Absolutely.
Mr. Tolliver, if you come back to the microphone. They have a condition over here of no violent contact, which means I cannot suspend probation upon paying the fine. But I can make it non-reporting. So in other words, once the fine is paid off, you don't have to report probation.
Okay.
Are you in agreement with that?
Yes, ma'am.
And it looks like a older. Right, and like, and he needs to be not breaking any laws and he needs to not. So like she says, the non-reporting would be better because it kind of looks like if he.
Judge, I've sent over both of those probation sheets for both of my pleas.
All right, as soon as Mr. Randall confirms that, you're free to go.
Thank you, Judge.
Yeah, we have.
All right, Mr. Tolliver, it's non-reporting, okay? On the show cause calendar, folks. Position number 1, Shackleton McHenry did not show up.
That's from 2015. What does the court usually do as a result of the?
You can null cross it because it was driving while license suspended or revoked, or you can issue a bench warrant. Or you can agree to a reset to see if he shows up again.
When was the last time he was here?
Let's see. Which position are we on? Your
Number 1 on the show cause.
Oh, sure.
September 8th, he received notice in person. September 8th, he also filed a change of address.
2023?
Yep.
Am I being recorded?
Yep.
Okay, well, we'll be asking for a bench warrant, please. Thank you.
Right. On the brake light and the driving while license suspended, it's going to be a $200 surety bond. It's 100 on each count.
Yeah.
You know what? I'm going to do this as a signature bond through the jail. So it's going to be 500 on each count. It's a $1,000 signature bond through the jail. If he gets arrested, that will be his note that he failed to show up in court. Okay.
And I'll review the case.
All right. Position number 2 and 3 have been reset to motions calendar on January 19th, 2023. 2024, sorry. Okay. We can stop the recording now, Mr. Glanville, and save the space for another day.